ಇದೆ ಇನ್ನೊಂದಕ್ಕಿಲ್ಲ ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ. ಇಲ್ಲ ನಾನು ಕಂಪ್ಯೂಟರ್ ಬ್ಯಾಂಕ್ ಹೋಗಿದ್ದೆ ಇವಳೆ ನೀನು ಏನಿಲ್ಲ ನಿಂದು ಇದನ್ನ ನೀನು ನೋಡ್ಕೊಂಡು ಮಾಡ್ತಾರೆ ಅಂತ.
My lord, serial number 18, my lord. I think the court is muted. I think the court is muted.
Yes, after vacation. Yes, next.
My lord, serial number 42. My
She will
lord.
call the list. Yes. Take his.
Thank you, madam.
Give it to the PS. Yes, next.
Page-wise adjournment, page number 3, serial number 10, page number 4, serial number 11 to 14, page number 5, 15 to 20.
Serial number 18, my lords.
Yes.
My lords, there is some inconvenience, my lord. May I request it to post after the vacation,
This is
my lord?
after vacation.
Grateful.
Serial number 14, my lord. We have received a new counter offer from the opposing counsel just last night. So
What is this modification? What is that we will see? There is nothing. It's for the court to.
And for the petitioner, my lord, your lordship had indicated an inclination to dismiss the application for modification on the last date, to which they said, please give us a last chance to negotiate. Your lordships had given until Saturday for them to do that. They have reached out to us only on Wednesday with an offer, my lords, to which we have responded yesterday, and now they're asking for more time. I pray that your lordship.
we need to seek instructions from our client, your lordship. Just last night we have received the offer.
I think I'll dismiss this or the entire modification petition itself. How many times for these kind of reasons the court who filed this why is
The
it
husband has filed it, my lord.
no why is it today? This IA is filed by whom?
The IA is filed by them.
No, it is this today. Court has given the date today.
The court has given a date today saying last chance, otherwise dismiss.
We'll see when the matter comes. Yes.
Page number 6, serial number 21 to 26, page number 7, 27 to 34,
Serial number 26.
20?
26.
Oh.
The lordship is the lower courts in the family court. The orders have the judgment has already been passed.
Please use the mic.
Your lordship, the matter has already been disposed in the family court.
Yes.
So
it is submitted that the main MC itself is disposed of in the family court. Nothing survives for consideration in this petition. Dismissed as instructions. Yes.
serial number, page number 7, serial number 27 to 34, page number 8, 35 to 39.
Serial number 39.
Serial number 39, my lord. There's some 39, my lord. I seek for adjournment, my lord.
Inform the other side.
No.
Wait for them to come. Yes.
Serial
Page
number
number
35,
9, serial number 40 to 42.
serial number 35, my lord.
Seek for an adjournment, my lord. I informed the respondent counsel.
Which one?
Serial number 42.
Yes, after vacation.
Serial number 35, my lord.
Yes.
35.
Apply for a week time, my lord.
Why?
Need to file an objection.
Uh,
Respondent.
we'll see when the matter is. We'll see when the matter is. Please call the list.
Yes, ma'am. Serial number 1 for dismissal matter. Serial number 1, Kiran Kumar for petitioner. Savita.
Appearing for
In
the
view of the
respondent.
order passed by this honorable court, the petitioner not complied, the trial court has issued a FLW against the accused, Your Honor. And he was served on 21 days in JC and he has paid it 87,000 rupees, Your Honor, of maintenance. So, and so because of, he is not earning the money because of he's only a labor, Your Honor. And the respondent itself is working as a staff nurse and more than 40,000 rupees as assets and she has declared, Your Honor. So now, by virtue of this honorable court, he is not complying the order because of his no money, Your Honor. And because of FLW issued by the trial court, he was in JC of 21
You
days.
have already said
Yes, sir.
that. You have already said. I understood that.
21 days he was served in JC, Your Honor.
Yes. Yes.
Now it may be posted for the final hearing, Your Honor.
What file hearing? Not required. We will hear it right now.
Yes, sir.
Argue. Yes.
Marriage
15,000
was
is granted.
performed 3/6/2013, Your Honor.
You are on what ground before this court? Why the order is?
Order 15,000 passed the order of trial court, Your Honor. And moreover, she is filed in assets page number 57, Your Honor.
Hmm.
In F column, monthly income 39,800 rupees as on the date of filing the assets and liabilities.
How
Your Honor.
much she is earning?
30, she is earning, Your Honor.
How much?
39,800.
Hmm.
Likewise, Your Honor, the petitioner itself is assets and declared as is a coolie. Page number 64 of the petition, Your Honor.
What is your income?
Per day 300 rupees.
Hmm. Now please come to the discussion. Para 27.
Yes, Your Honor. So for PW to examine, Your Honor. So regarding regarding
Please read.
so far the testimony of PW is concerned, they said they have examined Meenakshi, wife of Tejkumar on 14/8/20 when she approached examination of pregnancy and accidentally had a prescribed or relevant medicine and issued mother card, etc. Is also stated that he subject to her to blood test scanning, etc. And 13/2/20 she was made and delivery baby as the child was died in the home itself, and on the basis of the medical records he could give the said evidence. Even he has stated that as per the information furnished by the said Meenakshi.
Yes. What is the evidence with regard to his income?
My lords, para number 17 of the same judgment.
Come to that.
It would be equally relevant to refer the testimony of RW1. In the chief examination, he has reiterated the ground of the defense raised by him in his objection statement. In his cross-examination, however, he has admitted that he is doing a automobile engineering work, which would falsely his statement in the objection statement, and that he is doing any other work other than the agriculture. He is also admitted that there is a family-owned agricultural land. This has never been put forth in the asset and liabilities at all. He falsely contended before the trial court stating that he is a coolie. He is a ITI graduate who is working in the automobile engineering work, and he is earning handsome money of 30,000 rupees. And he never files the statement of 3 years of bank statement at all. He never files it, but he contends that he is a coolie. And considering that, my lords, in para number 11 and 11 also, he admitted he is having a relationship with the lady one Meenakshi, and it is substantially proved by the witness PW2 also by leading the evidence, my lord. Wherein till date, my lords, the child is aged about 12 years, which is studying in 6th standard, my lords. Till date, he has not paid single penny for the education also, my lords. It is paid by the mother only. And mother having the independent and dependent mother also who is aged.
Her income is 40,000. Her mother is dependent on her.
Please, my lord, they are staying in the rental house.
On
Same contented in my asset and
Did you
liabilities.
not file your bank statements before?
Allah, before this honorable court, I filed the assets on
Let's see, where are your bank statements?
Sorry, on 4/4/2025.
See,
Yes,
let
sir.
us see your bank statement.
Yes, Your Honor.
That copy has been not served for me, my lords. I have no copy of the said bank statement. No, no. And more importantly, the pending maintenance is 8 lakh rupees, my lords, as of today.
No, what he says is he's not in a position to pay. That's why he's even he suffered imprisonment also.
My lords,
He was in jail for 20 days.
please, my lords, I admit it.
On 4/4/2020, I filed documents, Your Honor, along with produced the his salary certificate on. So total month 9,200 rupees, and entire last 3 years I produced this bank statement, Your Honor. And also, he has aged mother and father also suffering from the age ailments, Your Honor. Except his salary, there is no other source of income. There
There
is
is a salary, you're a coolie.
yes, Your Honor.
Uh,
Some company has issued the receipt, Your Honor.
What does it mean? That you have suppressed the material facts before the court. When you say that you have no other income, you are doing agriculture coolie work, where from this company has come
This
into
is
picture?
this under daily wages. He was working under the daily wages work, Your Honor.
You say you're an agriculturist.
No, there is a 1 acre of land in the ancestral property, Your Honor. Except there is 1 acre.
Okay, let us see your pleading.
So,
Let's see your pleadings. Where are your objections?
Regarding the agricultural land, it has not been disclosed anywhere in the objection also, my lords.
No. What did he say about his income?
It has not disclosed, my lords.
But at least what is the government when you have stated that he is earning so much? He must have he must have filed his objections.
was denied in the objection, Your Honor. Regarding the
While denying that, you should also say what is your income?
because there is no other except except.
What is that? What is that except? Where did you say? Please show to the court. You should say in your objections that except this, I don't have any other income. Where did you say? Please come to your objections.
Yes, Your
At
Honor. I
page
see,
number
Your Honor.
50,
Yes, Your Honor.
51. Nothing. You don't say what you're doing in the entire objections.
Clearly, they filed a formal objection. You were in the trial court.
Huh?
In the trial court, they filed that objection.
About the trial court objection?
Yes, Your Honor.
Where is it?
But did not make any objection regarding the his assets and liabilities, Your Honor.
To the IA, you didn't file your objections? IA seeking maintenance or this is a
125
125?
petition.
You have filed your objections,
Yes, Your.
but you didn't say anything about your income.
But they denied, Your Honor, because of.
What you denied, please show. What you denied. Let's see.
In 43, Your Honor, para 6, the other contention of the government made a 5 petition not true and correct, hence the petitioner put to same, Your Honor.
What is that? How is 46 relevant to this?
40, sorry, 40,
46, how is it relevant?
43, Your Honor.
48 is your objections.
That is annexure fee 42, Your Honor, my objection.
Where are the objections?
This is MC petition what they have filed, my lord, for that
No
one.
objections in this petition or
Yes,
file?
it is
Have
filed,
filed,
Your
my
Honor,
lord.
Where is
42, Your Honor.
Annexure C, my lord. Annexure C, page number 42. At para number 4 and 3, my lord.
Respondent submits that respondent is doing agriculture work and earning income. So it shows that you made a false statement before the court, and on the other hand, you will show some receipt by some company. There are so many entries in your bank account.
Well, I am not declaring, Your Honor, I am an agriculture holder.
But in the assets and liabilities, they
annexure.
denied.
Annexure C, Your Honor, just is denied, Your Honor.
Read paragraph number 8. Read at page 44.
If my lordship permits, can I?
Yes, Your Honor. But 1 acre of land is owned, Your Honor,
Please
by
come.
ancestor.
Agreed with the orders passed with miscellaneous number 20 of 20.
Along with that, documents are produced. 1 acre of 40 say I have produced before this court. Your Honor.
Nobody asked you to say if every person who is having 1 acre of land is not agriculture coolie. You said, I'm doing agriculture, the respondent doing agriculture work and earning income.
And
On
automobile.
the other hand, you say that I'm working in a company is giving that, I'm working for 300. Which stand we have to take?
Like, as of now, what are the documents I received, Your Honor, I produced before this
So the
court.
orders passed in criminal miscellaneous 20 of 2022 dated 8th August 2024, whereby the court had granted maintenance of an amount of rupees 15,000. The husband is before this court. The wife had filed a petition seeking maintenance of an amount of rupees 30,000 per month to her and the child. The court had, it is a case that the husband is working, doing, having automobile, working in automobile shop and earning sufficiently. According to the wife, her salary is 39,800. The husband filed his objection stating that he is only doing agriculture work, and as stated by the wife, he is not working. Before the court, in the cross-examination, it is stated that he has accepted in the cross-examination that he is doing automobile engineering work. Before this engineering work, and considering all that, the court had granted 15,000 per month to both the petitioners. The petitioners, learned counsel appearing for the petitioners submits that he is working as a daily wage laborer, and he has also produced before the court that he is getting 300 per month, 300 per day. Further, it is submitted that the 300 per day. It is further submitted that he is not having sufficient income, and in the income he has to take care of himself and his parents, and granting an amount of rupees 15,000 is on the higher side. Learned counsel appearing for the respondent submits that the petition is taking different stance with regard to his employment. At one stretch, he says he's doing agriculture work. At one stretch, he says that he's doing automobile engineering works. And at another stretch, he says that he's working as a daily laborer. It is submitted that before the court, he has not filed his statement of assets and liabilities. In response to that, land counsel for the petitioner submits that he has filed the same before this court. This court has perused this court. Land counsel for the respondent submits that there are no grounds and the writ petition needs to be dismissed. Next para, having heard so and so. The whole purpose of filing the objections, statement of assets and liabilities is to put forth before the court what are the assets and liabilities and what are the objections of the petitioner, objection of the parties. Unfortunately, in this case, the husband had taken different stands at different levels, and before the court, he has not even filed his statement of his bank statement for the 3 years, as per the judgment of the Abbot's Court in Rajesh versus Neha. The perusal of the order and also the submissions that are made before this court clearly demonstrates that the petitioner is suppressing the material facts before the court, and he has not come to the court with clean hands. The court had granted maintenance to the petitioners at 102 petitioners 15,000. Admittedly, the wife is earning 13,800. In those circumstances, the court was not right in granting 15,000, granting maintenance to the wife also. And considering all these aspects, this court is modifying the order. The order dated so and so is modified, and the amount of only the daughter is entitled for maintenance, and the amount of maintenance is reduced from 15,000 to 10,000 accordingly. Disposed of.
Cell number 2, Sridhara B. for petitioner.
Appearing for the
Saubhagya D.
The court has directed me to furnish.
Yes. What
Court
is
has,
that?
on last date of hearing, court has directed me to
Take that.
furnish the memo of payment of school fee, hand fee and everything, Your Honor. Furnished copy.
School fees 84,000. Medical
That is
expenses.
of the year 2024 to 25.
During the year 2024, March 2024 to March 2025, to Pragna Child Development Center, 1,57,000. Toys and other therapy material as per the advice of the therapist, 12,000. Transportation for therapy from house Banshankari to Basvanaguri, 30,000. For home tuition, one Kirti per year, 24,000. That is from what? That is everything is from 2/2/2024 to.
That is February till 24-25. It has been spent by her.
That's
Now,
what
in the next,
no, 2/2/24 to February 25.
yes, Your Honor.
School fees. That is only for 2024.
That is early payment. This below I have mentioned for this academic year which she has spent.
Yes.
My lords, order which challenge my lords Annex H, 25,000 has been awarded, my lords. Other than school fees, they have not claimed. Before this court, my lords, we are undertaking, my lords, we are ready to pay half of the school expenses.
Sir, asked to get
yes,
all
yes,
this.
yes, my lords. That is, we are also admits, my lords. Only because, my lords, 25,000 awarded as a maintenance is, my lords, higher side.
How can it be under these circumstances? Under
Lords,
these
I'm
kind of.
No, my lords, that I am ready to pay half of the amount, my lords, expenses.
What is your salary?
My lords, my salary is 44,000.
40?
44.
What is her salary?
Her salary is 69,000. Even I am admitting that, my lords, I am ready to bear half of the expenses of the child, my lords.
Educational expense. I mean,
Yes,
all the half you are ready.
Yes.
Then who will take care of the child?
Child maintenance, my lords, I am ready to pay 15,000 per month, my lords. Not, my lords, 25,000 is a higher side.
That is in fact, that's good for you.
He is paying only educational expense, half of the educational expense.
Because
what
she
he
is
is
also
getting.
earning.
No, Your Honor, he is getting around 70 to 80,000 per month.
Even
Yes.
assuming that he's getting 70,000, she is also getting.
Your Honor, entire expenses is going for the caring of the child only. She is taking care. She is providing food. She is providing cloth. She is taking care of the.
Please understand. All the medical and educational expenses of the child, half. Apart from that, he will pay the maintenance of 15,000. What is
Apart from education, he is paid.
education, medical expenses, both the parents will have 50-50. And he will pay 15,000 as monthly maintenance.
No, apart from. Your Honor, court has granted 25,000 as for medical and educational expenses. That is off of the expenses only, Your Honor. Every month she is bearing around 40,000 for the expenses of the medical only. Medical education, Your Honor. I have produced document before this honorable court. He has already filed memo for withdrawal of the petition before the trial court.
At least you understand what the court is saying and what the calculation would be.
Yes,
Now,
Your Honor.
15,000 he is paying. He has to pay 15,000 from now. That's what I'm going to pass an order. 15,000 monthly expenses. Apart from 15,000, whatever are the medical and educational expenses are concerned, both of them will pay. We will have to bear 50%. It would be more than 10,000.
Much of.
Now, it is not now, it is like first the court has to convince the advocate. Advocate has to
Sorry, Your
convince the
Honor.
client.
What I thought it is out of entire out
No,
of.
but I'm very clear. But why
Yes,
should you think? Because all of you are carrying the same emotions of your client, so you will be complete in a block. That court is going to do something,
Sorry, Your Honor.
and I have to protect my client. Please come. Where is the order? Page number?
79.
79. Agreed with the order passed in I number 4 in MC number 33 of 2023, dated 7th February 2024, whereby the court had granted maintenance of an amount of rupees 25,000 per month. The husband is before this court. Then counsel appearing for the husband submits that he is ready to take care of the half of, as both the wife, almost both the wife and husband are earning, is ready to take care of how he is ready to bear half of the educational, medical expenses of the child, and he is ready to pay an amount of rupees 15,000 per month towards maintenance. Then counsel appearing for the respondent submits that the child is having special needs, and he has to undergo therapy sessions and also require a special teacher, and she has been paying a lot of amounts towards the educational and the medical expenses of the child. Considering all that, the court had granted 25,000 towards the maintenance, and there are no grounds to interfere. Next para. Having heard the land counsel the petition, so and so, there is the material on record. It is an admitted fact, both the parents are working. According to the husband, he is working less than the wife. According to the wife, he is earning more than her. But the fact remains is both of them are working. When both of them are working, the expenses with regard to the child have to be shared between them equally. From the date of application till today, whatever are the expenses that are borne by the mother, she shall by way of a memo, she shall file before the court, and half of that amount the husband has to pay. when he is bearing half of the medical and educational expenses as fairly submitted by the learned counsel for the petitioner, an amount of rupees 15,000 would be sufficient for the other needs of the child. In that view of the matter, this court is passing the following order. The order dated so and so by so and so is modified. The petitioner father shall continue to pay, petitioner husband shall continue to pay an amount of rupees 15, shall not continue, he shall pay an amount of rupees 15,000 as maintenance to the boy and shall bear 50% of the medical educational expenses of the child. Next, from the date of application till today, whatever are the expenses that are borne by the mother towards medical and educational expenses by way of a memo shall be placed before the trial court. And if any of the and basing on that, the husband shall pay the amount within 2 months from the date of the said order and continue to pay the expenses. The mother shall in advance inform the father about the by way of the demand that is made from the school or any other document to be sent to the father, and basing on that the father shall pay reimburse the mother accordingly.
One findings, my lords, if she is changing the school, my lords, she shall inform the father.
If she wants to change the
Medical
school,
for medical
as a father
please.
is also bearing 50% of the expenses, the same should be informed to the father. On consensus, they should change, or else she should move the court.
Please.
Cell number 3, Vikas M for petitioner, Murthy DL for respondent.
The order under challenge is interim maintenance order, my lord, in the divorce case, my lord. One instruction I have got is the main petition has been dismissed for non-prosecution, my lord. However, till the case was pending, the interim order will operate, my lords. My lords, if my lords should kindly see the page number 21 of the order, my lords. Page number 21.
Yes.
There it stated, my lord, from the undisputed facts, it is seen that the respondent is now entitled for 6,000 per month as interim maintenance in criminal miscellaneous
Once the main
proceedings.
application is dismissed, we will not adjudicate on this, whatsoever the reason. We can't adjudicate on the.
There's one change of circumstance. Court passed this order on the relief, my lord. They're already receiving 6,000 as interim maintenance in the
Whatever it
maintenance
is.
case.
Now it-
25,000 has been ordered in the other case.
Merges
my
with
lord.
the main order, there is no question of deciding an IA after a main application itself is dismissed.
But my lord, till the disposal murder or interim order.
So till that day, whatever is the order that is passed, that would be
Yes,
subsistent.
there, my lords, order is passed on the belief that 6,000 is ordered as
But you
interim
have
maintenance.
to, now you have to question it when wherever you are questioning the main order, because it has already merged into that order. We can't help it. It is submitted that the
On
main
restoration,
MC,
liberty may be given to challenge it again, my lords.
main MC itself is dismissed for non-prosecution. Once the main petition is restored, they are at liberty to review make an application to review this order. Accordingly, this petition is dismissed. Yes, next 4.
Cell number 4 for orders matter, Vidya S for petitioners, Rajesh Shetty.
Respondent in this matter.
Preparing for the petition, my lord, we're seeking time for hearing.
Because I already filed my memo of calculation on 28 days. That holds good here. There is a amount deposited by them before this honorable court.
Learned counsel of the petitioner has filed a memo of calculation stating that the maintenance amounts are cleared and the arrears are paid. According to the learned counsel, the respondent, an amount of rupees 45,000 is due. Learned counsel for the petitioner submits that an amount of rupees 50,000 which is deposited is not calculated by the respondent.
That DD is there in the file, Your Honor. That is not encashed. That is there in the file.
Which file?
Your Honor's file. The
See.
DD, that it has become stale now.
Then let us give him give him the DD for that amount. Where is that? Why is it before this court? The
My
DD.
lord, when stay was granted,
You can
during-
always, why should we, you can
no, my lord,
always. give
second
the-
installment, we directly deposited the account.
Where is the DD? Yes, it is.
Yes.
When was it?
Month of April.
No. Why it is 28/4/2025?
Yes, my lord.
How many months?
3 months has
3
expired
months.
now.
7. The petitioner has deposited the DD before this court for an amount of rupees 50,000. And this is dated 28/4/2025. As the same is expired, the petitioner shall pay an amount of rupees 50,000 directly to the respondent within 1 week from today.
2 weeks, my lord.
Within 2 weeks. What is the difficulty when the
My lord,
DD you have already taken?
No, my lord. The
Can
thing
transfer
is,
the same amount.
no, my lord, that first I should get it in cash and then, that is why, my lord, 2 weeks.
And the registry director written the DD.
Permit me to take
Yes,
that
next-
DD.
Next.
Interim order may be extended.
Interim order granted is extended till the next 5.
Number 5. Cell number 5. Adopting.
After vacation, no representation.
Ladyship, I appear in this case, Ladyship. Item 5. I only request Ladyship for an accommodation because it is for arguments and I could not come today to Bangalore.
Yes, this is after
Can it be
vacation.
can it be on the 9th or 10th, Ladyship, of
That we
October?
don't know. I can't give the dates after vacation. Yes, next.
Cell number 6.
Grateful, Ladyship. Thank
Sita Devi MP for petitioner. The responding
For the petition, my lord, so there's a direction before by your lordship to sit the child yesterday to take from 6 p.m. to 9 p.m. my lord.
Huh?
From 6 p.m. to 9 p.m. That has been complied.
That has been complied with, my lord.
Please, my
Not
lord.
few submissions, my lord, regarding this visitation. It was ordered that your lordships had said they have to develop the bond between the father and son. Now there was a nanny who the son has not met for 6 months, and that nanny comes and tells, oh, I've been crying, I want to see you, why did you leave and go? Lord, why such questions for the child, my lord?
I'm not able to understand. What is that?
It was a nanny who came in the visitation. He has taken the child home. The nanny has come and spoken to the child, I've been crying because you've left here and gone. Why have you gone? Why have you left this premises and gone? Why put up such questions to the child, my lord?
What happened to your client because of that?
Why to even
No. What happened? So everything what now the court will write. Father will say this. The response should be this. Father will ask this question. The son should respond like this. And nobody in the house should be going here and there when the boy is around. Unreasonable.
It's not that, my
Now I
lord.
request,
Yes.
my lord, the vacation starts from tomorrow for the kid, my lord, till 5th. May I request for alternative days?
Yeah, when the vacation starts?
From tomorrow, 27 till 5th, my lord.
27 to?
September till 5th October. Lord, may I request for alternative days?
Yes. Alternative days like 27th, 29th, 1st, then 3rd.
Please, my lord.
4 days.
4 days.
My lord, can we have this continuously, my lord? They are planning on going for a vacation.
Then we can do it.
Have a
Yes,
continuous.
Then what we'll do is,
Please,
whichever you want. First half or
half,
the second half?
We'll communicate with them.
No. 27, 28, 29, or else 30th, 1st, 2nd, because 3rd is the reopening.
5th.
6th is the reopening.
Sixth
my lord.
is the
Monday.
reopening.
So,
So
till
27, 28, 29, 30th is one. 1st, 2nd, 3rd, 4th is the other.
1st, 2nd, 3rd, 4th. 2nd, 3rd, 4th, 5th they can do, my lord. Till
2nd,
Sunday.
3rd, 4th, 5th.
11 to 1, my lord.
He has no choice.
Please, my lord.
I'll dispose of this matter.
Indeed, my lord. My lord, the Sunday visitation can also be 10 to 1.
Sunday
we would-
visitation, the time may be extended, my lord, because I have sought, my application is for from Friday till Sunday, my lord, overnight custody. Now, my lord, the child is good enough being born. There is no necessity to mother to be present or facilitate the child. In respect
So
of
now
that,
what was the order of the family court?
10 to 1 p.m. only on Sunday, my lord.
10 to 1 p.m. on Sunday?
For 3 hours, that's all, my lord.
Where is the place of visitation?
It was a neutral place that they would choose, my lord, either the mall or.
No mall. Why should he is a boy and They stay very near. Why should they go to mall every day?
No objections.
So let's see the order.
Yes,
What
my
is
lord.
it that is granted?
Page 19, my lord. Annexure A. The reasoning starts from 29, my lord.
Hmm.
In para,
Akshay from 10 a.m. to 1 p.m. on every Sunday.
please, my lord.
My lord, the video calls have been happening every day. We have not stopped that, my lord.
So instead of this is on
Sunday, my lord, it has
Sunday.
been granted.
So then it's 10 a.m. to 5 p.m. on Sunday.
My lord, may I request for overnight, my lord, from Saturday at least till Sunday, my lord.
Let it go on for some time. Yes.
My lord, the one request, my lord, let it happen from 10 a.m. to 1 p.m. for some time, and then based on how it goes
It will
on,
go
then they
when
can extend. My lord.
agreed with the word order passed in. I number 3 in GNWC number 477 of 2024 dated 24th April 2025, whereby the court had granted visitation to the father from 10 a.m. to 1 p.m. on every Sunday near the house of the mother in her presence. The father is before this court. The court has also observed that the father can talk to the son for 5 to 10 minutes every day between, what is the age of the boy? 13.
8.
8. The boy.
9, my lord. 9 years.
The boy for 5 to 10 minutes every day between 7:30 p.m. to 8 p.m. either through video or audio calls. The father is directed not to give objectionable food which is harmful to his health, and he shall not cause any inconvenience to the child during the visitation. And it is also directed that the parties shall maintain peace and harmony during the visitation. Then counsel appearing for the father submits that they were separated when?
December, my lord. 24.
December 2024. Till such time, the father was having the father was sharing a good bonding with the child, and now they also stay nearby.
Please.
They stay.
Sadly, from 8 to 7 kilometers.
Huh?
8 to 7 kilometers.
This
10 kilometers.
They stay within 10 kilometers. And considering the age of the boy of 8 years, it is submitted that the court ought to have granted the overnight visitation. Further, the visitation that is granted is a very short period, that too in the presence of the mother. It is submitted that it is not appropriate. The court ought to have taken into consideration the fact that the boy needs to develop the bonding with the son, unless and until the sufficient time is given in the strained relationship between the parents. It is not possible, and the court has failed to appreciate this aspect. It is submitted that even in the ensuing the Dasra vacation, the boy may be permitted to, the father may be granted daily visitation in the holidays. Next para. Land counsel appearing for the respondent submits that the father in the course of visitation, instead of trying to develop bonding with the child, is trying to feed the child with unnecessary information and also trying to find fault with the mother, which is not in the interest of the child. Considering all this, the court had rightly not granted the overnight custody and is not entitled for the same. The arrangement that is made is a well considered one, and the courts have to take slowly when it comes to the matters pertaining to the custody and visitation, or else it will have a psychological effect on the child. Next para. Having heard the counsels on either side, there is the material non record. This court has interacted with the father, mother, and the child on 3/9/2025, on 11/9/2025.
It was on 18th, my lord. Date was given on 11.
No, on 18/9/2025, this court had interacted with the parties. With that, then an order is passed on 23/9/2025. Extract the order. Today it is submitted by both the counsels that the visitation, it is submitted with the land counsel for the petitioner that the visitation went on well. The counsel for the respondent also, though has not pointed out pointed out any serious concern about the visitation. However, she has raised before the court certain issues which are really not relevant for consideration for granting the visitation. Considering the fact that the child is there, both of them were living together till December 24. The father shall have more time to continue the bonding with the child. Considering the interest of the child and also balancing the interest of both the parties, this court is passing the following order. The order dated so and so, passed by so and so, is modified. The father, during the Dasra vacation, can have the visitation from 10 o'clock to 5 o'clock
My
on
lord,
second, third.
my lord, Dasara vacation, we can have it from 11 to 1, my lord. Every Sunday, Dasara vacation, 11 to 1, the visitation can happen, my lord.
On 5, on second, third, fourth, and fifth. You can have the visitation between. You can exercise. You can have the custody of the child between 10 and 5. 1 and 5, which is convenient.
6 p.m. or 10.
10 and 5, which is convenient to the boy, and the place convenient to the boy and to the father. Number 2. The court had granted visitation on Sunday at the mother's place between 10 to 12.
10 to 1, my lord.
10 to 1. Even on Sundays also, the visitation is between 10 to 5. Then whenever the child wants to speak to the mother, when he was with the father shall facilitate the same. And as it is directed in the last order that the father shall not discuss anything with regard to the mother of the child, and he should only keep the entire visitation shall be only for the bonding or developing the bonding between the child. Anything that comes to the notice of the court that the father is feeding unnecessary information to the child, that would be considered in passing further orders. Yes.
So this arrangement may be for 3 months, my lord. Further liberty may be granted me for modification of the visitation rights in trial court, my lord.
Oh, you are already decided to, again file another application.
No,
First you enjoy with this, then we'll see.
Much obliged.
Yes.
Serial number 7. Ashok. Papa.
APF for the petitioner, the wife's petition for.
Why this matter was mentioned yesterday without even informing the others?
My lords, I have messaged him, my lords. I'll produce the copy of that. But he has not replied. Continuously have called him also. He has not picked up the call.
Not engaged.
So then what does it mean?
Then I
It
made a
means-
submission saying
No, but that's not not a fair submission.
Kindly.
The whole purpose of the court asking you whether it is informed is whether it is in his knowledge or not. If he has not responded to your messages or responded to your calls, that means
I
it
informed
is not
the-
in his knowledge.
My lords, I informed
It's
this court.
unfair. Please don't make those kind of submissions.
This is,
Yes, please come to the order.
This is wife's petition seeking interim custody of the child.
Where is the impugned order?
That lordship find at page 11, my lord. And the operating portion of the order, your lordship find at page 22, where the trial court has ordered that the respondent is directed to hand over the minor child, Lishant Gowda, to the interim custody of the petitioner on every Monday, Wednesday, and Friday to the petitioner from 9 to 5 p.m. till further order. and the petitioner shall pick up and drop the child
Yes, what
at
is
his
what
residence.
is the age of the child?
2 years 4 months, my lord. It was forcibly taken from the custody of mother.
Who is the petitioner in this?
Petitioner is the mother. She is the petitioner. And the child is with the father now.
When was the child taken?
Child was taken on 12th April 25.
Take one.
The allegation is the petitioner has got illicit relation with some other person. That is the entire case. Then I filed a petition and through the local police, the custody of the child was taken.
When is the order passed by the court? Where is the first order?
That is the order, my lord.
IA number 1, where is IA number 1 order? This is IA number 2.
That is the 11th, page 11, my lord. That is the order passed on 5th July 25.
No, why should a boy aged about 2 years 4 months shall be with the father?
She handed over the child. I'll come to that, my lords. All the documents have been recorded. The petition was filed suppressing the material facts. Your lordships may kindly come to my objections, my lords. She has not produced all the documents. I'll show to your lordships, my lords.
They themselves face, my lord.
Let him.
Your lordships may kindly come to page number 17, my lords. This is the petition which has been filed by him before the trial court. Para number 5, my lords. The petitioner submits that the para number 5, my lords, submits that the dissents reached the grave proportions and being the marriage which led to the petitioner and the respondents, my lords, petitioner and the respondent thrown the petitioner out of the matrimonial house for a silly misunderstanding on 12/4/2025 and now started living separately. In this paragraph, he says, my lords, your lordships may kindly come to the statement which is recorded before the police, my lords, where she says she does not want to live with the husband anymore and she hands over the child and she gives away. Your lordships may kindly come to page number 39.
59. An objection. Translation copy.
Translation copy, my lords.
Translation copy of statement.
Why it has reached the police?
My lords, what happens is from several months, my lords, she was having an illicit affair with one particular boy called Pavan. Thereafter, what happens, my lords, I repeatedly, my lords, my landlady, I was living in a own house with my mother and parents. Thereafter, she demands for her to have a separate house. My lords, I obtain a separate house for her and I put her in a rented house where I was living with her, with the child. Thereafter, what happens, my lords, the said boy who is her paramour, my lords, started visiting the house. When I am a government employee, my lords, where I go to the work, my lords, all of a sudden this paramour, once I leave to the office, the paramour comes to the house and stays with her. Thereafter, my lords, they lock the child inside the house and they roam around. That all the WhatsApp chats are there and recorded in the documents are produced. Thereafter, my lords, what happens, one particular day, my lords, on 13th, I tell her that I am going to Belgaum. I purposefully, my lords, the incident was informed to me, this particular incident was informed by the landlord to me. Thereafter, my lords, on 13th, I tell her that I am visiting Belgaum for one of my friend's marriage. At that particular night, my lords, she roams around, she locks the child inside the house and she roams around with the particular boy and comes back to the house. And that particular night also, my lord, she was having an illicit affair. That particular video, my lord, says the child is sleeping next to her, my lord, with the paramour. They are in a compromising position. The entire CCTV footage, my lords, I have produced in the objections, whatever it is there. My lords, I gave a complaint and the police visited at 12:45 at that particular time along with my parents. Thereafter, my lords, they were caught. Then the petitioner was sent to the police station and they summoned her parents. And there, my lords, the statement was recorded. She says that she does not want to live with me and she hands over the child and she goes from there. And then, my lords, this petition has come to be filed.
See this statement.
Kindly, my lords, if lordships come. Page number 39. Harshita, wife of Channa Krishna, 25 years, so and so, so and so. I am residing in the above address since 7 to 8 months, along with my husband Channa. The complaint given by the husband Channa Krishna on 15/5/2025 is read over and understood to the contents herein regards. Regarding to the said complaint, I state that the marriage of Channa Krishna shown by my father and mother on 15/11/2021. According to the Hindu rites and customs, after the marriage, I was living in Heggalli, Bangalore, along with my husband, mother-in-law, and father-in-law. After I became pregnant. When I had gone to my parental home at Kattiguppe, my mother-in-law and father-in-law were staying in the house with the elder sister of my husband. Myself and my husband were living in a separate house since 3 months. My husband is working in Bescom at Soladevanahalli. Every day he used to go to the work and return home. Now I am having
Why
a
would
mail.
somebody give this kind of statement?
Kindly, my lord.
How anybody will give this kind of statement to the police saying everything that I am bad?
No, she recorded herself. Photographs is there for the mahazar which has been conducted on that particular day. Your lordships may kindly see page number 60 and 61. They will dispute the statement, my lords, but the photographs doesn't lie. Page number 59, annexure R7. If your lordship sees, my lords, the lady is standing in middle. Next to her, my lords, to the left hand side, it is her paramour. Left to her, my lords, it is her sister. Right side, it is her father and mother. Your lordship may kindly come to next page, my lord, 60. Along with the entire family, my lords, the mahazar was conducted. My lords, the position of law today, my lords, an FIR cannot be registered. That is the reason, my lords, why the NCR was registered by the police. In her statement itself, she says she does not want to continue with the marriage. Then she hands out the child, she goes. She says, I'll take the child's custody in the court. And also, my lords, if your lordship sees the transcript of the messages, my lords, in a particular month of page number, I'll continue with the statement, my lords, if your lordship sees. Page number 39. Page number 40, my lords. I'll continue from the correspondence words, my lords, which is in 7th line. In the meanwhile, Pawan came in contact with me through my school.
I've read the entire one.
Kindly, my lords. The next, my lords, the transcript I have produced in the WhatsApps, my lords, your lordships may kindly peruse. Page number 75 of WhatsApp.
Yes, what do you say?
My lords.
Counsel for the petition.
Yes,
What do you say?
My lords.
No, whatever allegation through intervention of police, all these photographs were taken, my lord. And even whatever the ground he urges, it may be a ground for divorce, but it cannot be a ground for seeking custody, my lord. And the child is and not a good wife means she is a bad, not a good mother to the child, my lord. And these are all the police statement. It is all not admissible also, my lord. And as to their convenience, the police, according to him, he visited at midnight and he took the petitioner along with the so-called paramour, and they took all the photographs. Even the child is not found in these photographs, which true to their convenience they have taken the photographs.
I have produced the videograph, my lords, your lordships may peruse. 1 second, my lords, page number 75, your lordships may kindly peruse. The transcript, my lords, I'll finish my submission, please. Last, my lords, what happens here, my lords, these messages are in Kannada, my lords. Here, what happens, she says, my lords, to the paramour that you come home, you pick me. My lords, I'll just read out in Kannada. ಏನ್ ಮಾಡ್ತಿದ್ಯಾ ಪಾಪ, ಹೊಟ್ಟೆ ನೋವಿದೆ, ಕಮ್ಮಿ ಆಗ್ತಿಲ್ಲ, ಹಾಸ್ಪಿಟಲ್ಗೆ ಹೋಗೋಣ, ಸ್ನಾನ ಮಾಡಿ ಕಾಲ್ ಮಾಡು, ಬರ್ತೀನಿ, ತಿಂದ್ಮೇಲೆ ಬರ್ತೀನಿ, ಆಗಲೇ ಅವಾಗ ತೋರಿಸಿದೆ, ಅಲ್ಲಿ 20 ಮಿನಿಟ್ ಬಂದೆ, ಪಾಪುವನ್ನ ತಿನ್ಸಿ. She locks the child inside the house, my lord. Supposedly, my lord, she, in her transcript, she says she is pregnant. She goes with him to the government hospital. Then, my lords, at that point of time, nothing is communicated to me. The child is locked inside the house alone in a rented house.
Please come.
And your lordship may see the order passed, my lord. And they are staying at a distance of 35-kilometer apartment. Even in the order, the visitation right now was given to the petitioner mother to drop and pick up the child between 9 and 5 on Monday, Wednesday, and Friday. And now, and And for that purpose, the petitioner alone has to go. Now she is working in Aditya Birla Capital, my lord. And the respondent husband, he is working as a lineman for electric supply company. And even when the child was sent to my house, as per the order, my lord, the child was suffering with severe infection and no treatment was given. Consequently, I have admitted the child and the child was inpatient for 3 days. And the child was fully neglected, my lord. And now the petitioner is staying with her parents. They are all below 50, 52 year, my lord. Her mother is there. She will take care of it. And whereas the father of the respondent is, they are senior citizens. And whatever the document, whatever the allegation is made, that is subject to proof, my lord. Now itself we cannot come to any conclusion.
There is a page number.
Which what?
Impugned order.
Impugned order is that page 11. It starts, and the operating portion of the order is in page 22, my lord. The respondent is directed to hand over the minor child.
22.
Page 22, internal page.
Please come. Agreed with orders passed in I number 2 in JNWC number 163 of 2025 dated 5th July 2025, whereby the court had directed the father to hand over the minor child to the interim custody of the mother on every Monday, Wednesday and Friday from 9 a.m. to 5 p.m. The mother is before this court. The mother has filed JNWC number 163 of 2025 seeking custody of the child. The age of the child is 2.5 years. According, it is the case of the wife that the husband has thrown her out of the matrimonial home on 12/4/2025 and started living separately. He has a habit of scolding, shouting on her parents in a very vulgar language and abuse them to the maximum extent. And the father has no love and affection for the minor child and is only trying to take away the minor child permanently with forcefully and selfish goals. The innocent minor child will have to suffer his future if he is left with the father. And there's a duty cast upon the mother to protect the minor child. It is stated that the father is not taking care of the child and is busy with his work, working at Bestcom as lineman. If the husband continues to have the custody of the child, he might not take care of the health. To that, objections were filed with the father that she is not a fit and proper person to be appointed as a guardian. When he has shifted into a rented house, he began receiving calls from the landlord informing that an unknown man is frequently visiting the premises during odd hours in his absence, taking undue advantage of his work schedule. The wife allowed the individual to visit the house repeatedly, which came as a shock to him. On 14/4/2025, on the information of the landlady, he went there and she was caught with the boyfriend in the presence of the jurisdictional police officials who accompanied him on his complaint. It is a case of it is stated that on the day the police are visited and before the police, she has given a statement that she is having illicit relationship with one Pawan and she wants to, and she has handed over the child also to the husband. It is the case of the husband that while she was having illicit relationship with another man, she neglected the welfare of the minor child. On multiple occasions, she left the child in the care of the unrelated third parties and remained absent for extended periods. And she is also involved in consumption of alcohol and other intoxicating substances. It is stated that when she was caught along with the paramour on 14/4/2025 in a compromising position with her paramour at the rented house, the minor child was right beside them, and such immoral and indecent behavior in the presence of the minor child is not only but the minor child poses a serious threat to the child's psychological and emotional well-being. The tribunal, the family court, has observed that by considering the custody or visitation of the child, the paramount consideration of the court is the welfare of the child. In this case, there are allegations and counter allegations by both the parties. The police papers, including the statement of the parties, WhatsApp chats, are placed before the court. The photos of the wife and her paramour and her alleged paramour, as well as a video in the pen drive produced by the husband or at the pre-trial stage. Then the court has felt that all these things have to be proved at the time of trial and pass the order whereby granting the custody, interim custody of the minor child to the mother on every Monday, Wednesday, and Friday from 9 a.m. to 5 p.m. Then counsel appearing for the mother submits that the boy is aged 2.5 years, and considering his tender age, he should be within the custody of the mother. Further, according to them, when the boy came to the mother, he was not in a good condition, and he was having infection, and the mother has taken him to the hospital and joined him. The father is not able to take care of the interest of the child along with the mother. Her parents are there who can take care of the child, and the interest of the child is being with the mother. It is submitted that just because, even assuming that basing on the photographs, it cannot be said that she is a bad mother. And all those photographs cannot be considered at this stage, which are subject to proof. It is submitted that the custody of the child pending proceedings shall be transferred to the mother. Next para. Land counsel appearing for the respondent father has reiterated the contention that are raised before the court and also drawn the attention of the court to the statement given before the police, the WhatsApp chats, and submits that the pen drive is also placed before the court, which shows that the day when they found her along with the paramour, the boy was next to them. It is submitted that in these circumstances, where the mother is not taking any interest in the child, it is not in the well-being of the child, and the court had rightly passed an order and no interference is called for. Next paragraph, so and so. This court has perused the order as well as the photographs that are placed before the court, the statement before the police, and the WhatsApp chat. As rightly argued, and counsel for the petitioner mother at this the subject to proof, and that can only be elicited during the course of trial before the family court. However, looking at the photographs that are placed before the court and the WhatsApp chat, comma, and this court is dealing with the welfare of the minor, the court has to prima facie, having looked at these documents, prima facie feels that giving complete custody of the minor child to the mother at this juncture is not in the interest of the minor. The court had, considering all the aspects, has passed a balanced order, and this court do not find any reasons to interfere with the order. Accordingly, petition is dismissed.
Serial number 8.
And let continuously 3 days be given. That order may be modified because morning dropping and picking up. It is because they are staying at a different distance of 35 kilometer, and during monsoon it will be very difficult.
So what to do?
Continuously custody may be given to the mother 4 days or whatever in a week, so that it is convenient to pick up and drop after continuously 3 days or 4 days.
Instead of alternative days, we'll do it because 35 kilometers, why the child has to travel? So what we do is
1 week or 2 weeks, whatever.
From that's Monday, Wednesday, Friday. The court said we say Monday, Tuesday, Wednesday. The next, but as far as the order granting the custody, interim custody on Monday, Wednesday, and Friday is concerned, both the parties are staying at a distance of 35 kilometers, and it is difficult it is not in the interest of the boy to travel 35 kilometers for 3 days. That is 35, 70 kilometers for 3 days in a week. In that view of the matter, the order of the court is modified as follows. The mother shall have the interim custody of the boy on Monday, Tuesday, and Wednesday. She shall pick up the child at 9 o'clock on Monday and shall drop him back on Wednesday at 5 p.m.
Serial number 8. Serial number 8.
Appear for the petitioner, my lord. We'll do the needful. Kindly grant us a week time, my lord.
Any interim order you have in this?
No, my lord.
No interim order. The what happened to this order? Have come. You argue or your senior argues?
Senior will come and argue them.
Ask him to come. All the record is there. Yes. Yes.
Serial number 9. Serial number 9. Manju not expert petitioner.
We have complied with your orders yesterday, Your Ladyship. We have filed it in the registry as well.
Who is that appearing?
They have not come, Your Ladyship. I don't see them online as well.
As per the memo.
As per the memo, Mr. Anand. We have served the respondent as well also on WhatsApp as well as email. The birthday is today, Your Ladyship.
Then counsel for the petitioner submits that as per the order passed by this court, he has served the hand summons on the counsel appearing for the respondent as well as the party and filed the memo to that effect.
Affidavit.
In the name of so and so, what's the name of the advocate you said?
Mr. Anand, Anand S.
Mr. In the name of Anand S. Where is the impugned order?
The impugned order is at page number 36. It says 10:30 to 5 o'clock. We have arranged celebrations with the entire
The
family.
petitioner is permitted to take the child for celebration of the birthday of the petitioner from 10:30 a.m. to 5 p.m. in the hotel or in any public place, and the mother of the child is also to be accompanied with the child in the said place. What is the age of the child?
3 years, 2 months.
Then what is wrong with this order?
last time, Your Ladyship, he had a wonderful time with me in his birthday, 1.5 lakhs, and he had a celebration and party. So all we are requesting is they should remove alienation because she's doing that now. That is why they are absent. And the false submission made is the child has not seen the father. We are even undertaking to give you a DVD of the entire celebrations today to allay any fears for safety of the child. She did not even allow the child to eat the cake and the lunch, which was prepared on that day. Also, Dasara vacation has just been summarily rejected.
But the petitioner father is before this court, agreed with the order passed, agreed with the order dated 19/9/2025, whereby the court had permitted the father to take the child and celebrate the birthday of the child on 26/9/2025 from 10:30 a.m. to 5 p.m. in the hotel or in any public place, and the mother of the child is to be accompanied with the child to the said space. And counsel submits that earlier also the father has celebrated the birthday of the child.
Every year, in fact. Every year. In fact, both of them celebrated 17 times.
Celebrated the child's birthday. And we knew of the differences between the parties. The presence of the mother would not be, and it would unnecessarily cause complications. Considering the submission, the order of the court dated 19/9/2025 is modified in view of the same, this court is passing the following order. The father is permitted to celebrate the birthday of the child and take the child from 10:30 a.m. to 5 p.m. in the hotel or in any other place, public place.
Your Ladyship, they are staying hardly 2 kilometers within range. So we want to celebrate at the father's house.
He is permitted to celebrate the
in
birthday.
the evening. If it can be extended by 3 hours, we will take it in
It
the
is only
afternoon.
10:30 to 5. How can you have? Then what about mother? How will she celebrate?
It's not the child's birthday, it's the father's birthday.
Father's birthday.
Yes, Your Ladyship. That's why I'm requesting in the evening.
Celebrate the
Grandparents,
birthday of
everybody
the
has come.
father. Father on 26/9/2025 from 10:26. Hence, the father is permitted to celebrate his birthday with the child, and is permitted to take the child on 26/9/2025 at 2 o'clock, and shall drop him back by 9 o'clock in the evening.
On the second aspect, Your Ladyship, the Honorable Trial Court has just rejected Dasara.
That we will see later.
Then may I move?
That is not the order impugned now.
It is because the memo contains Dasara prayer, but she has rejected
All
it.
that we will not grant
Your
without the
Ladyship,
presence of the other side, and at the fag end I will not.
Then may I request to move the vacation bench and it can be
No,
listed?
I'll not. If you want, you can move. I'll not give you any permission. Yes, next.
No, if you do not give permission,
Not
it won't.
disposed of.
If you, yes,
I'll
if you do
not,
not
I'll
give
not.
permission, it won't be listed, Your Ladyship.
Yes,
That is
next.
why.
Cell number hearing on interlocutory application, cell number 10.
Appearing for the petition, I filed
Mamata
an
Shetty.
application for recalling the order of DNP dated 2/9/2025, Your Lordship. On that day, I was held up in court hall number 2, Your Lordship. That's the reason I could not appear. And my colleague tried to appear through VC. Due to some technical glitch, she could not appear, Your Lordship. That's the reason.
The IA is filed. IA 1/25 is filed to recall the order dated 2/9/2025 for the reasons stated. The order is recalled. Post this matter after vacation. Yes, next.
Interim order.
Interim order is extended.
Much
Cell number 11.
Great.
Kiran Veeran.
Here for the petitioners. Application to recall, my lords, the order dismissing the petition for non-prosecution.
Why now it has become a fashion now. Not appear when the matter is listed, then come up with this application.
My lords, I apologize at the time. NOC
No,
was not-
whenever the matters are dismissed for default, first it will come in the list. First day you don't come. Second day it will come in the list for dismissal, and second day it will be dismissed. So why on the door both the days why there was no representation?
My lords, if I may, we've actually recently come on NOC because
That is not the problem of the court.
my lords, at the time of
Every
dismissal-
time the matter is dismissed for default, new advocate comes on record. That cannot be a ground.
Lords, at the time of dismissal, the petitioner was actually not aware that the matter was listed before High Court.
No, it is very unfortunate. Court is giving you, it is not that the moment the matters are listed, they are not dismissed. Court is giving enough time posting it for again dismissal and inviting you with a red carpet welcome, and then when you're not coming, then only they are dismissed. No, it is not a matter of routine every day. One day dismissal and one day to restore it.
Apologize, my lords. Seek the indulgence of this court.
IA number 1025 is filed to recall the order dated 29/8/2025. The reasons that are stated are not at all convincing. In spite of the same, balancing the interests of the parties, this IA the so-and-so is recalled on the condition that the petition shall pay an amount of rupees 2,000 to the legal service to the High Courts Advocates Association. Yes, next.
My lords, if I may just make another submission on maintainability.
I will not look into anything now, post after vacation.
Very well.
Yes.
Cell number 12. Cell number 12.
For the petition.
Yes.
MV Revan Siddhaya.
Lordship has directed me to seek the clarification with regard to the payment of arrears of maintenance. I moved the memo requesting the court to post it on 25th. The court has posted to after vacation, Your Lordship. In the memo,
Matter after vacation.
an
Next.
interim order is there.
Your Lordships, one humble submission may be made, my lord.
Huh? No, that I understood what he is saying. Yes, suppose this matter.
Your Lordships, one humble submission may be made
Interim
on behalf
order
of the
will be
respondents, my lords.
extended.
If it's only the arrears of rent, that's the reason why seeking adjournment. I oppose to that, my lords. However, this month's maintenance also not being paid.
I am due to pay it this month. Your
19th
Lordship.
is when you were supposed to pay as.
Hear that by 5th of this, what was the date?
19th of every month.
And by 19th of, it is already not paid.
August Not
paid.
The amount is not paid by tomorrow. The stay granted by this
maybe,
court stands
I may
vacated.
be
No
permitted-
further.
Permitted to pay it on Monday, Your Lordship, because
Why should we? No, it is a conditional order that you have to pay by 19th.
Yes, Your Lordship.
I will
I
not
may be-
clarify.
I may be
The order of
permitted
the
to-
court is that the amounts have to be paid by 19th of every month.
Arrears?
If it is
No, no,
not
Your Lordship.
arrears, monthly payment.
With regard to arrears, there is a
Monthly
clarification,
payment
Your
has to
Lordship.
be made by 19th of every month. If it is not paid, then the no clarification is required. The stay granted by this court automatically stands vacated, and it is for the respondent to file an
Lordship,
EP.
With regard to arrears of maintenance, it's a
I'm not saying arrears, I said monthly
Yeah, that
payment.
is what arrears has come.
That I said, I clarified it.
Yeah.
Your Lordships.
Not paying it is.
No,
you
that I'll
file
pay
EP.
the due. Whatever the
But-
due, I'll pay it, Your Lordship.
Let him pay, let him file EP. The state
I'll
goes.
pay it, Your Lordship.
Yes,
Your Lordship, with respect to the arrears as well,
Well-
my lords, I just,
this is matter after vacation.
Your Lordship, one humble
Same
submission
what-
with respect to the arrears, my lord. It's only based on their own memo for calculations before Your Lordships.
Please understand, all orders can't be passed on the last working day. Please
No,
understand.
I just don't want the interim order to send operational.
That's why I
favor, my
clarified
lords.
that you can file an EP if he is not complying.
Very well then, my
Yes,
lords.
next.
Cell number 13. HK Honnegowda for petitioner. R. Kotwal.
The respondent.
28/7, the Honorable Court had directed to file the bank statement and the assets and liabilities.
But anyhow, what we'll do is, we'll hear this matter and if it is required, we'll remand it or else we'll.
My lord, I've been told that the matter itself is dismissed for non-prosecution, the main.
Then what
matter.
is to be decided in this writ petition?
Insofar as the, insofar as what is the arrears claim is there, the whatever order which my lord is going to pass, considering the material which we have placed now, right now.
When the main matter itself is dismissed for non-prosecution,
Yes, ma'am.
after that question of deciding an IA, will not arise at all.
But my liability to pay the, since I've,
Whatever on the day of your non-prosecution, whatever is the order, that would prevail.
it's not my petition, it's other side's petition.
My lords, the miscellaneous petition is pending. Also, notice has been issued, my lords, for.
That's it. Then we will not do any
Because-
exercise in this petition.
My lord, may I just
Kindly
make,
have it after vacation because the matter is listed on 15th. Lordship may kindly have it after vacation. Then by that time the matter is
Yes.
may I
revived.
make one short submission in this regard, my lord? On the last date of hearing, this honorable court directed that the bank statement be filed and the assets and liabilities be filed. The interim order which came to be passed by this honorable court is of the year 2021. And thereafter, we have made certain payments. I'm only bringing it to the notice of the honorable court, the 12/3/2021 order.
What I'm saying is all the text.
No, leaving it and to be taken up after the vacation is
Not only vacation, as long as that application is not restored, the MC is not restored, I will not entertain anything with regard to this writ petition After vacation, if it is not restored, we'll dismiss this writ petition also.
Dismiss the writ petition, but
When the main main MC itself is not there, where is the question of
no,
deciding
the
an IA?
financial liability which has accrued.
That would be decided by the executing court when he files an IA for recovery of money.
Yes,
That
ma'am.
would be decided by the executing
I leave
court.
it to my lord on that. No, I was only hopeful of convincing my lord for the disposal of this petition itself, because we already paid 3 lakhs.
Because it makes, when the main petition is no, it is
No,
no
to
more
the, up to the date of disposal, my liability will be there.
will
To-
be there. That would be whatever is the order as on today, as on that day, that is date of dismissal.
Yes, ma'am.
Whatever is the order that is that.
Subject to be modified. My endeavor will be before this honorable.
But when it is, once the final order is passed in that, the question of modifying this order will not arise.
I leave it to my lord on that.
But
Maybe
my lord,
a
what
date.
has happened is, my lords, on 2 occasions he was not present. It was posted for
After-
cross-examination.
Yes, after vacation.
Would my lord consider fixing a date, my lord? I leave.
Yes.
Grateful.
Interim order to be extended, I was told.
What interim order?
There is an interim order subject to me paying that.
How can we extend that interim order?
My lord, in this writ petition. Kindly see, my lord, that's it. That is the end.
That is in this writ petition. The
Yes.
main MC itself is dismissed.
No, otherwise.
Dismissed for non-prosecution.
No, my
There is a
lord,
question of-
no, there is a difficulty in so far as the amount of which I am liable to pay as per the trial court order, which stood modified by this honorable court by order dated 12/3/2021, which I have complied.
Please tell the court, when the main MC itself is dismissed for non-prosecution, there is nothing pending before the trial court. Where is the question of passing an interim, extending an interim order in this writ petition?
My lord, because of the 4 years gap which is there before this honorable court, I mean, for whatever reasons, kindly see the other aspect of it. What, as a result of not extending the interim order, what will be the prejudice to me? I have to convince.
Fun aspect.
Yes,
And
ma'am.
what is legally, how a court can continue an interlocutory order or any orders arising out of an interlocutory application when
Yes,
the
ma'am.
main petition itself is
No,
not
as per their own memo of calculation filed before this honorable court, I am liable to pay a sum of 7 lakhs.
Everything has to be, it will be decided before the appropriate court.
But-
We can't decide a writ petition and we can't grant a stay when the main MC itself is dismissed and it is no more there.
My lord, I understand that, madam. Maybe I am unable to communicate. I am unable to convey. Kindly hear me for a minute on that. There is inability on my part to convey it properly. I must say so. For the reason that 12/3/2021, an order came to be passed, thus subject to payment of 3 lakhs by the petitioner, the maintenance awarded of 12,000 rupees per month is stayed. The matter came up before this honorable court. When the matter came up upon the submissions of both the counsel, this honorable court did pass an order that let there be a statement of bank statement and the assets and liabilities to be filed. The other side have not filed it. We have filed it. Now only consideration which I am seeking by this honorable court is that unless the interim order is passed, the interim order is extended, the consequence as a result of that is that my liability which is determined by the trial court will get activated in spite of its dismissal for non-prosecution, even though the case is dismissed for non-prosecution. When I am able to demonstrate this before this honorable court that having regard to the financial status of the petitioner, 12,000 per month awarded by the respondent is incorrect and may have to be reviewed. Now, so far as till the date of dismissal of the main petition, after that date, there may not be any controversy till that date, unless I am protected by an interim order. What will happen is their own statement I am reading. I am not getting my word. As per the memo of calculation which they have filed, they say that we owe them 5,91,000 further, apart from 3 lakhs which is paid and in terms of the interim order. My lord, I did make a submission on the last date of hearing that straight away insofar as the period of date filing of the application, and at that time it was not disposed of, straight away it could be brought at 6,000 rupees. I am willing to pay because God has blessed me, and for the past 1 year I have been doing well. And to close this maintenance part, 12,000 as determined by the trial court may not be appropriate, and my lord may consider reducing it to 6,000, and we'll pay that entire amount. And the case will, the MC case will, will go on as per whatever the.
It's not there. The MC case is not
Yes,
there now.
but now the recovery, I may have to be protected for the earlier period. I oppose dismissal of the.
Whatever, as on today, what is the order of the court?
Order of the court is that subject to me depositing 3 lakhs, there shall be a stay of the interim order passed by the trial court awarding maintenance of 12,000 rupees per month. So that protection I require. What is?
Have you paid?
Yes, yes. Undisputedly, I paid 3 lakhs.
So then, from now onwards, there can't be any action.
No, the interim order is till the next date of hearing. Kindly appreciate interim order.
Oh, what I'm saying, their MC itself is dismissed.
No, it will. It may take a month or 45 days for.
That day we will revive it. Now you are complied with the interim order.
Yes, my lord, no difficulty. I have complied with the interim order insofar as 3 lakhs is concerned. That has a rider that till the next date of hearing. That is a rider. If that rider were not to be there, I would not have insisted upon. There is a rider, my lord. Kindly appreciate this aspect of it. One minute. And they take up.
One respectful submission. The interim order which has been granted to the husband, my lord, it cannot be a ground for escaping his liability, my lord. He has not even paid single penny since last 3 years. That the arrears which he has paid, that is the only thing which he has paid, my lords. He is earning more than 70,000 rupees per month. I'll file my assets and liabilities also, my lord. The matter may be posted after vacation.
And we will be deciding all this when your MC is dismissed for default. We will consider the IA here and we'll pass orders in the IA, and this will be executed by you or by him. What is the law? I'm not able to understand this at all.
My lord, it may be revived after.
If you have to revive, once it is revived, you will review this also. Whoever wants it can revive this also. When the main MC is dismissed, why would this court decide all this? Does this matter after vacation?
Execution is
and the
pending.
interim order that is passed is extended till then.
I'm obliged.
Great.
Cell number 14. Ayanathara BG for petitioner.
Lords, on the last date, your ladyship had said they should extend an offer. They did not make it by the date given. They said it later on. I've conveyed my offer to them. My lords, there's been no response.
Please come.
My lords, I had in fact conveyed my offer to them.
Now, this is whatever.
They have gotten back to me last night with a figure.
Whatever is amicable for both of you, do it. Court has no time for these kind of petitions.
My lords,
I will dismiss this IA number 1 of 25. Whatever is the order earlier.
My lords, the IA is for an extension and to allow me to sell the property in some time. Yes, my lords, any reasonable time, my lords, may be given if they are opposing.
According to you, when was this order passed?
My lords,
this order was passed on 25th July 2024.
Yes, my lords, I was given 1 year's time to sell this property at 3.5 crores, my lords. I have made efforts to sell it. That is not the problem of the court. That is what both you said so before the court and my lords, but there are market factors involved here, my lords. I have done my best to sell the property. I am now before this court with clean hands saying I have made efforts. There has been a lot of opposition and non-cooperation on their part. I'm only asking for an extension of the time.
Yes, I will grant. What is the extension?
My lords, a year's time may be granted for me to do.
1 year is
any reasonable time in that. My lords, I'll also point out the difficulty here. To buy the property my lords, if I may just,
not agreeable to that.
My lords, if I may just point out one last thing. I have brought an offer to this court.
Whatever, I don't want to listen to all
I have
these
brought a buyer to
arguments.
this court and put on affidavit the buyer's offer as well, my lords. They've opposed even that.
Application take out?
If I may just point out to the affidavit of the buyer. There is a buyer willing to buy the property at 2.6 crores, my lords. If that can be allowed, then both parties will get a profit out of this and be allowed to settle the loan and the EMIs.
Literally, you are turning this court to a civil court, executive
My lords, we've
court.
tried to. In fact, the councils have been very helpful as well.
1 of 25 is filed. Seeking extension of time by order dated 25th July 2024. This court has passed an order that the husband within a period of 1 year shall sell the property at 3.5 crores, and after clearing the bank loan and the amount that is contributed by both of them, remaining amount shall be shared between both of them equally. This was an order passed by the court basing on the submission that is made by the husband and the submission made on behalf of the husband. Then the present IA is filed, then this matter.
Because I'm also
on,
requesting for a reduction in the price point, my lords. I'm unable to sell at 3.5. It is not going in the market.
Proceeding sheet. On 13/8/2025, this court has passed an order. Then on 18/9/2025, an order is passed. Place this matter finally on 26/9/2025. And by the time the husband shall place on record the amount that he is ready to pay to forego his rights in respect of the property, or
Lords,
else
I
IA
have
will be
given them
decided
that amount.
on the merits of it. Now today, both of them, both the wife and the counsels appearing with the respondent submits that. One has given the proposal, other has not come up with it. And for the other, it is not agreeable. And with these kind of submissions are made today. And then a counsel appearing for the petitioner husband submits that the
Respondent husband.
respondent husband submits that she's not able to get the buyer, and the
My lords,
buyer,
I have a buyer at 2.6 who's put an
he was-
affidavit on
he
record
was-
in this court.
the
That may be taken on
buyer is
record.
available for an amount of rupees 2.6 crores and to 2.6 crores. This is not the concern of this court, and repeatedly these kind of applications cannot be entertained by this court. In spite the court is, in spite of though the court is not willing to go into these aspects, the court has given enough time to the parties, and they cannot reconcile. And this court cannot decide all these issues in a already disposed of writ petition. Accordingly, I number 1 of 25 filed by the wife is dismissed, by the husband is dismissed. Next.
Cell number 15. Sudeep Bangera for petitioner.
Yes.
I have completed the office objection, subsequent officer. I have completed the office objection subsequent which is raised by the office time.
As the petitioner has failed to comply with the office objections, the same was dismissed. The writ petition was dismissed. I number 1 of 25 is filed to recall the order date 22/7/2025. Thereafter, the writ petition has complied with all the office objections. Hence, the IA number 1 of 25 is allowed by recalling the order date 22/7/2025. Yes, what is the writ petition about?
Please, Mr.
Where is the order impugned?
Order is, my lordship, page 42, my lordship. That is passed by the trial court, my lordship, to pay the school fee and expenses, my lordship. 50%, but MC petition and restitution of conjugal rights, that is filed by the petitioner, my lordship.
Where
And,
is the order? I'm not able to find the order.
Page number 42, my lordship. The petitioner present, advocate for the petitioner on 5/2/2023 submitted that they are ready to pay the school fees of the minor child as paid in A number 7 by the respondent. Accordingly, the said IA is disposed of without getting the instruction from the senior advocate and party. This is submission is made by the junior advocate, my lordship. Hence, there is this order is passed, my lordship. That is challenged before
now
this
whatever
court.
submission you make, I dispose of this writ petition, and tomorrow again another advocate is engaged and said that this advocate has not taken instructions from.
Short date may be given. Senior will argue the matter.
Not senior. I'm saying that submission
That is
cannot
true,
be
my lordship.
accepted.
That is true, my lordship. My humble
This
submission
order, this submission is
Annexure B, my
made.
lordship.
Please wait. This submission is made on 24/3/2023. When did you file the writ petition?
Writ petition is filed on
On 2/8/2024. That is 1.5 years after the order is passed. After 1.5 years, your client has realized that such instructions are not given to him. And on that ground, this writ petition has to be entertained.
And that is not, yes, my lordship, that is true. But in MC, the Annex B, my lordship.
Please come to the grounds of the writ petition. Please read the grounds.
Please, my lordship.
What are the grounds raised?
Grounds is, my lordship, the impugned order Annex A directing payment.
Where is the family court has not properly applied its mind to the material? What material you place before the family court?
That is, my lordship, a criminal petition also filed by the wife, my lordship. In that petition, court is ordered to pay monthly 10,000, my lordship. And
In the entire grounds, please show the ground that you are now submitting before the court, that the advocate without instructions from the party had submitted it. Where do you get that?
Is page number 8, my lordship.
I'm looking at it.
Multiple order. The honorable court has some mention in the child, including the. My lordship, kindly see the next page number 9, my lordship. Mentioned, case is reopened for further argument for further hearing on IA number 7 by 24/3/2023. Then on 24/3/2023, the impugned order was passed, being on alleged submission of junior colleague of advocate for petitioner dated 6/2/2023. The petitioner humbly submits that after coming to know about the said submission, the petitioner got the case advanced.
What is this submission of the junior colleague was withdrawn? Where is that?
That is filed by the objection also filed, my lordship, and advanced application is also filed for withdrawing that submission, my lordship.
Where is this 24/3/2023 proceedings of the court?
That is 42, my lordship. Order for the page number 42, my lordship.
42 is the submission. Where
It's
is the
the
withdrawal
order,
of the
my-
submission?
Withdrawal submission.
That is what you wrote in your grounds.
Yes, my lordship, that is not there, but application is filed by the advocate, my lordship.
Where is that?
Advance application, my lordship.
Nothing.
Next, either, my lordship. It is there, my lordship. Application for the reason accompanying a memorandum of petition.
Where do you get that?
Please to page number 78, my lordship. Please to advance the above case on 27/2/2023 to 24/2/2023, my lordship. That is the advanced application filed by the advocate.
We'll dismiss it in the presence of your senior.
Please.
This is after vacation.
Achha.
Serial number 16. 16 Arun Govindraj.
What are your
petitioner.
instructions? It's paid by the mother or the father.
But I don't have that information yet. I will get it. I was not able to secure it in 2 days.
But I placed the blank statements on record.
If I don't have it, then I will fairly submit on the next day that I don't have it and she has made the payment. But as of now, I do not have that information.
Basing on this, I'll pass the order. And I'll also record your submission because no further, that is very much evident from the records that he has placed.
The Lordship may just give me 2 weeks time. I will list this after the vacation, and if I have it, I have it. Otherwise, I will say that I do not have it.
This is matter on the reopening day.
Obliged.
At the request of the respondent, no further time shall be granted.
May I
Yes.
make a request?
Obliged.
Does not sound unreasonable. Your Lordship has heard the matter, my lord, on 3 dates. My request matter be parted, not because
Yes,
I'll argue online.
Parted.
Good.
Serial number 17. Nan Gurappa Balluli for petitioner.
Madam,
Raju.
respondent wife, my lord.
This
My lord,
17.
memo of calculation, my lord. Their due of 6,10,000, my lord, to the wife.
Your Lordship, in this case,
Huh?
in the 17 and
Please
17.
use the mic.
My lord, 17 is in the petitioner. In this case, your lordship, there was ordered the interim order, and because they are stated on last date of vacation, they have filed the for announcement of petition. Once during the course of the FR stage, they have given. Once it is a number, so this has to be, along with that, it has to be listed. Accordingly, actually, this was listed and I produced the additional documents.
Now, in your case,
Please.
that is WP, first WP is yours or second is yours?
First is mine.
First is yours.
Mine.
So in the first case, what is the order passed by this court?
Your Lordship, on 19/8,
Huh.
19/8/25.
Monthly maintenance of 20,000 per month each to so and so.
Please.
Then finally, what is the, they shall be stay. Continue to pay an amount of rupees 20,000 per month to the child by 5th of every succeeding month.
Please.
When is this order passed? 19/8. September, have you paid?
Pardon?
September, have you paid?
I paid 50,000 rupees before the trial court. We given the check before the trial court, family court
DD
only.
of rupees 50,000.
50,000
Given
we
DD of 50,000 rupees, my lord. I'm filing memo of calculation where they
No,
due
that
of
is not required at this stage.
Please.
The court said, have given him how much time?
4 weeks, my lord.
4 weeks from the date of receipt of order.
And arrears to be paid. If arrears is not paid, then it's subject to vacating. That is not paid, my lord. I'm filing memo of calculation.
After vacation?
My lord,
If he has not paid.
And they have to comply with the office objection.
Not, please wait. If he has not paid the money as per
Please.
the order passed by this. court,
Please, my lord.
It stands vacated.
Please. Yes.
Order is very clear. You
Please, my
file
lord.
your EP.
If I'm allowed to file the memo of calculation before this
File it
court,
in the section, in the registry. Yes,
then
next.
interim order stands vacated, my lord, since they have not paid the money.
No, we paid that.
That submission, my lord, if
We
only
paid
that is.
before the court below. And you supposed to comply the office.
Have read the order?
I've read the order, my
No,
lord.
I will
What I'm
not clarify it. Every one order will not be clarified in the
my lord,
subsequent
if
orders.
no such order is
Please.
passed by my lordship, then in lower court, I may not be able to file for an application, my lord. If there's a detailed
Court
order.
understands English. In that it is said, if the amount is not paid, the stay granted by this court stands vacated automatically.
Please.
You will show before the court that
Please.
he has not paid the amount as per the order.
He's paid 50,000, my lord. Arrears is not paid is my submission.
That is also understood.
Please, my lord.
Even if arrears also not paid, it will
Obliged, my
stand
lord.
vacated.
Obliged.
Yes, next.
Obliged, my lord.
And at the same time, my lord, their petition has to be.
Office objection shall be complied with within a week, or else a writ petition shall stand dismissed. 17.1. Next.
Obliged.
Call the next case.
18 urgent, serial number 19, Rajshekar S for petitioner. 19.
Yes.
My lord, a short question.
Where is the impugned order?
Impugned order, my lord gets it at page number 94, annexure J.
90?
94, my lords. And the relevant portion of the order is at page number 104, para 21 of the order.
The petition is directed to pay 10,000 towards interim maintenance of the minor daughter. In the disposal, in addition to the maintenance of rupees 25,000 as ordered in criminal miscellaneous. 25 plus 10, what is your salary?
My lord, salary of the husband is 1,80,000.
80.
80. Salary of the wife is 1,10,000. Age of the child is 4.5 years. In divorce proceedings, my lords, 10,000 rupees is already granted. And that, my lords, on the last occasion, my lords.
Not divorce proceedings, it is.
That is in domestic violence.
Criminal miscellaneous.
Please, in domestic violence proceedings, 10,000 is ordered per month. And that order has been getting complied. And there's no arrears as on date. And no, my lords, in the MC proceedings.
You are paying 25,000 per month.
Which one, my lords?
You are paying 25,000 per month.
My lord, 15,000, what has happened is, HRA, it was granted as an HRA to the wife. My lord, that was brought to the notice of the court that she is residing along with her father in a very palatial building. His father he retired as a secretary in, my lords, in the Vidhan Sabha. That was brought to the notice of the court. And secondly, where she was employed, house rent allowance was also granted to her.
No. You please clarify.
Listen.
In addition to maintenance of 25,000, court has granted 10,000, it becomes 35,000.
Please.
Are you complying with the 25,000?
10,000 rupees have complied. As to 15,000 HRA which was granted, that is a subject matter as challenge pending before this honorable court in criminal revision petition 1157, wherein granting of HRA is illegal. That order is stayed by this honorable court. So as on date, my lords.
You're paying that 10,000. In
Please.
addition to it, now it is 20,000. When you are earning 1,80,000, what is the difficulty in giving 20,000 to the child?
My lords, I have two submissions which I should fairly submit. One is, my lords, my wife is an earning lady. both of us will have to, my lords, contribute for the welfare of the child. Now there's 10,000 rupees is paid by me. 10,000 he needs to contribute. My lord, for a child which is 4.5 years, I ask myself this question: whether 20,000 rupees per month will it not suffice at this stage, please, my lords? I ask myself this question. So
then now she's a working lady. She has to go out. Who will take care of the child?
the main purpose is, my lords, my father-in-law, who is now a widower, he is the person who is, my lords.
Absolutely no reason to interfere at this stage. Let her come, we will see. The list is marked after vacation.
No,
Petition is permitted
one
to
submission, one submission I have, only one submission. 10th, in the divorce proceedings, my lords, the matters got posted for cross-examination of, say, PW1. From that date, my lords, this application is filed. 10 hearing dates have passed therein. And this is treated as only as a reason to stall the proceedings, whether such is a conduct.
See, once she comes, notice to the respondent, and shall file a memo. Once a memo is filed, is the matter.
My lord, as to compliance, I'm filing a memo here to indicating that I have complied whatever I need to do as
Not
on.
necessary, you can find in the registry.
Till number 20, Kiran Sebastian Rosario for petitioner.
Just today morning, because yesterday evening I was told that it was numbered. Today morning I have filed, my lords.
Yes.
I will.
I'm for the mother in this case, my lord.
Where is impugned order?
At 49 page, operative part is at page 49. I'm directed to hand over the children tomorrow, that is overnight stay.
40?
40 at page number 49, my lord. To hand over both the children.
To the petitioner during holidays from 10 a.m. to till 5 p.m.
Yes, my lord. Also, at page number 8.
Like now we are concerned with this Dasara holidays at this point of
Correct, my lord. At page number 85, there is a writ petition which has already been disposed by this honorable court, wherein the previous order was modified, overnight stay, and 10 a.m. to 3 p.m. on Sundays was given in the presence of the grandmother because there are certain allegations against the father. And in the presence of the grandmother, even that order he has violated. Whenever we handed over the child, the grandmother was not there. And the second point, even the arrears of fees he has not paid, whichever directions were given. With this serious allegations, my lord, and previously also we put forth before this honorable court, the trial court has not taken into consideration this.
What allegation?
There is a POXO case filed on him, my lord, and a B report has been filed. He's influenced and the matters coming up. All this was placed before this honorable court.
No, the same order, what was passed long back, is passed now also. Why it should be?
In the month of June, we have come before this honorable court. 4 writ petitions
But
have
it is
been.
11 a.m. to 2 p.m. till disposal of the case.
My lordship?
Order at page 85. 11 a.m. to 3 p.m. in the presence of the grandmother.
Yes, my lord. This is in his house. This was for the visitation. Overnight was granted to him. That was modified by this honorable court.
Now, overnight, where did the court grant overnight in this?
Well, now the court has granted page number 50 from 10 a.m. on 27th to 5 p.m. on 1st.
Right, 110.
Milords, the order, I'm not sure why the order of your lordship is even attached herein, but I would say it's a wonderful thing because this court has considered all the aspects. In fact, it is wonderful that it is produced. Milords, this IA-6, if I'm not mistaken, was a day order passed by the trial court also. It was 10 to 2 only. There was nothing else, Milords. It was a day order on every Sunday, which your lordship modified in the presence of the grandmother. However, Milords, I think the order that has been impugned now is the 4th or the 5th overnight visitation in the vacation time that has been passed. And the father has been exercising.
Where is earlier order?
Milords?
There is earlier order.
He's not produced. I could do that.
No, at page number 76. That's the writ petition we have filed. 4 writ petitions are dismissed, common orders.
Your lordship is asking about the earlier orders. That is not true.
Overnight custody, when did he exercise from, emanating from which order?
Yes, Milords, earlier to 2024, 2000, even 25 summer vacation, your lordship has observed that it has spent itself. Can I just point out, Milords, your lordship's order itself, which they have produced? Page number, Milords, 84. 84, sixth point, my lords. Writ petition number 11619 of 2025, which, my lords, they're coming against a 2023 order filed in 2020, is dismissed as infructuous, as this petition is pertaining to the summer vacation of 2025, and the same is worked out, has spent itself.
Where are you reading? Paragraph
My lords,
number?
para 6, my lords.
Para 6 is writ
Para, page 84,
84.
ink page 84, point number 6.
It says writ petition number so and so is dismissed as
Yes,
infructuous.
yes, my lords. That's exactly what I'm.
As this petition is pertaining to summer
To summer vacation of 2020. It's been spent itself,
Hmm.
which was exercised by him, half of the summer vacation in this year, my lords. That's why I want to produce all the, in fact, my lords, I have photographs of him spending with the children and him and the petitioner together while everything I could place before your lordship. This is the, in fact, my lords, I think he'll be exercising the 5th vacation overnight custody order. Absolutely no, this is all apprehension of the mother.
No apprehension of the mother. This is
report
a
has
4
been
and a half
filed
year
in
girl child.
POCSO.
She went to the father's house. Over there, she apparently fell down. She had bleeding from her genitals. She was taken to the hospital. It was the doctor who informed the police. POCSO case is filed. He files for anticipatory bail. After 2 days, he withdraws the anticipatory bail on a guarantee that a
You said B report is filed.
Yes, my lord. B report is coming up on 10th of October for evidence. B report is filed on a guarantee that a B report will be filed. He withdraws his anticipatory bail. Influenced the police. Both of them, he's an American citizen, holding an American passport, constantly harassing. And in spite of that, we have approached this honorable court. This honorable court has heard us out. And you are of the opinion that overnight may not be given, but in the presence of the grandmother, he would exercise a visitation, and it's enhanced from 11 to 2 to 11 to 3. But the grandmother is not there. And he's also taking the children in the car to some unknown place to meet unknown people. If the grandmother was not there, the order clearly states that in the play area of the apartment. But he does not do that. He does not obey the order. Constant violation. It's a girl child, my lord. I have enough evidence over there. During the Mazar also, he's present during the Mazar. Refuses to go out. He's speaking to the girl child. So much of influence he wields. And even the order says the reimburse the mother for what was paid towards the school fees. Even that he has an intent to pay. At page number 59, I may read out para number 25 in his application. Second line, it is underlined and in bold. To that end, I paid the school fees of Rianch for quarter 2 24-25 academic year on July 1, 25. An amount of so and so. Gauri school fees for the current quarter has been paid, and I intend to pay the school fees to Gauri next year. Next due date. I intend to pay the past school fees paid for the year until now to the respondent. I intend to pay. The direction is given to pay, but he has intention to pay. There's no respect for this court.
It's absolutely not true, my lords. In August itself, he has made the first installment payment. It runs to about, she has changed the school voluntarily. So it runs to about more than 4 lakhs per year. This year, 2025, he's already paid the school fees. Plus the therapy the child needs, first son needs a therapy. Earlier, they used to spend around 25,000. She voluntarily changes to some other therapist, which I think he runs more than 70-80,000. For what reason? Not sure. However, my lords, he will abide by your lordship's order. He has already made the first payment, and it was just passed in June. And August, he has made the first payment. And academic year 2025, he has paid the fees. And it runs more than 4 lakhs. He needs some time.
I'm happy she's brought up this fact.
Do you agree that he had exercised overnight visitation so many times?
That is prior to this, after the order, prior to this writ petition orders, we had approached this coordinate bench. That time the orders were passed, my lord. We had no other option but to obey the orders with a heavy heart. It's a girl child, my lord. Girl child. And there was bleeding from the genitals. He is the one who has changed the innerwear of the child. The blood-stained panty has also been recovered. Supreme Court has recently passed an order saying, judgment saying that even touching the genitals amounts to sexual offense. He could have done something else. If it's a girl child, he could have called the neighboring lady or anybody he could have called. Why did he do something like that?
May I
And I'm happy that she brought up the therapy issue for the first child. We are spending 1,20,000 and my brothers are helping me to pay that. The order says to pay the school fees, but I have to see what's good for my child, what's best for my child. He has something known as GDD, growth development deficiency. He's unable to grasp. He's around 8.5 years today. I'm doing my best. Now, whether I spend 10,000, I get different treatment. I'm paying 1,20,000, 20 sessions per month. I'm running from pillar to post, my lord. And I have to drop the child, pick the child on a Sunday. I don't get, and the children of the opinion now that mama is very strict. She only teaches us, but it's fun time with the father. No, that's the opinion being built up in the child's mind. She's the mother. She also needs to exercise certain, and this is overnight stay. Let him continue with day stay with the grandmother's presence, and they are from Kalburgi, basically. Last time they made a submission that his mother is there in the house, which is a lie. She's not there.
Plus, I think
he doesn't have any female companion in the house. It's a girl child. Now she's 4.5, 5 years old. I'm only speaking on the welfare of the child, not the rights of the parties. Welfare of the child.
Plus, more often than not, we are okay with the mother changing the inner clothes of the small son. However, that should not be taken into anything. However, when the father does that, I think he should not interfere. I have not interfered his arguments at all. I do not know why the opposite counsels indulge in such things. Plus, when the father does the same thing, especially when the child has hurt itself, he himself is saying, she was playing on the slide, fell down, and there was small hurt, she was bleeding. That should not be made into a POCSO court, which is nothing but an abuse of the act itself, which I think the mothers are doing nowadays in pretty number of cases, my lords. I think even the Supreme Court has come down heavily on that. And recently there is a POCSO case filed against the mother itself for abusing the son. Why is it that it is taken as a rule that the mother can do this? He has not done anything that a prudent father should not do. And to color it like that.
So whatever it is, it's a matter of trial. At this stage, we have to go with what is, and when looking at the welfare of the child, the court cannot presume something that it might have not happened or it might have happened.
Absolutely.
But the court, no, what is the difficulty in giving a daytime custody of the child? Why should you have overnight?
Well,
every day you can have, you're staying nearby.
No, just because the mother files a POCSO case.
Unfortunately,
no, I'm just
not that,
plus,
neither,
even
neither you know nor the court know what is right in it. You may be trying to submit.
Absolutely, yes.
So we have to. The interest of the child is paramount. We have to think about, and at the same time, court is not trying to keep the child away from the father. We are trying to take the interest of the father also, and in the circumstances where if the allegations that are stated are right, then unnecessarily by orders that are passed by the court, we are facilitating or doing some injustice to the child.
Well, time and again, in fact, my lords, previous court in the same writ petition, that is, I'm talking about at point number 6, my lords, has had an opportunity to interact with the children, more so with the child, for 1 hour. I would say, my lords, I would also prevail upon this court to interact with the child, and whatever your lordship feels, we abide by that. But to say that
by interacting with the child, when the things have gone this far, we have to have some kind of a precaution for this.
Then it is the intention of the mother to put that in thought, to color it, to give it such a color.
A complaint is basing on the complaint of the doctor or whatever it is.
Well, it's not the daughter, it's the mother.
No, but
the doctor informed the police.
Generally, the doctor will call the social welfare people.
Doctor, he's taken the child to the doctor. The doctor has prescribed an ointment. He has handed over the child along with the ointment to the mother. Mother goes to some other doctor. Well, this is what, because the mother wants to bring such an aspect, because she's all along trying to keep the children away from the father.
During the Dasara vacation, the entire 10 o'clock to 5 o'clock, every day I have the visitation.
Plus, may I suggest something, may I suggest something? Just like your lordship has modified the earlier day visitation order that in the presence of the mother, the same thing can be done. I have no difficulty.
Yes.
Let the, yes, yes.
In the presence of the mother, not overnight.
No, my lords, his mother, of course the children will get opportunity to
Mother,
spend.
not overnight.
In fact, my lords, I would, my lords, I would,
Not 10 to 5, I can make it 10 to 7, but not overnight.
my lords, may I just prevail upon your lordship to have one interaction with the child before altering the order. In fact, my lords, the
Then
order
we
is
have
passed.
no opportunity. The vacation is coming.
That's their intention, to bring it on the last day of the board when order was passed on 19th.
Take
Please,
allegations.
23rd
Monday
they
I've
filed,
received
and
the order.
purposely
No,
they do
these
this, my
allegations
lords.
I will not
Just
stand
because
by.
I should not bring.
19th orders passed, I applied for the
Yes.
copy. It is posted on 25th. I had to move the file from the judge's desk to the
23rd.
copying to the department. Monday I received the copy. Tuesday I filed the case.
Plus 23rd
Tuesday
he
I filed
files
the
and
case.
he moves the
I've
court
moved-
yesterday and only
It has
evening
gone
it
for
is
scrutiny.
numbered.
It has gone for scrutiny.
Because
I've
he
moved it.
knows this
These
is
are
a
vague-
half a day
these are
and there
vague-
will not
these are
be any
vague
interaction
allegations.
with the
Yesterday
child.
also I had a matter before this honorable court. I've moved this case.
Plus she can bring the child even before 1:30. I have no difficulty.
I have served copy on him,
The
my
children
lord.
are extremely
On
comfortable
24th
and
on
happy with
24th,
him.
I've served copy on the advocate who's representing him in court. There's an endorsement also to that effect.
Fine. Questioning an order passed by the family court, whereby the overnight custody is given to the father from 10 a.m. to 27/9/2025 till 5 p.m. on 1/10/2025 during the Diwali holidays from 10 a.m. Diwali, that's days from 10 a.m. on 21/10/2025 till 5 p.m. on 22/10/2025. And during the Christmas holidays from 10 a.m. on 24/21/2025 till 5 p.m. on 28/12/2025. And during the summer vacation, we will not modify the entire order, only as far as the Dasara vacation. The other vacations and other things, after interacting with the child,
Plus
then only
that would wrongly influence the family court, and then he will.
No, I'm not disposing of. I am only as far as, because imminent necessity is for the Dasara. Only to
Imminent
Dasara I'll
necessity.
clarify and keep this matter pending. Once the matter
All right.
comes, we'll interact with the parties.
Milas, may
then
I-
we'll look at it.
Absolutely, Milas. May I suggest something? Let the mother, his mother, I'm talking about, just like your lordship had done it earlier, let her be in the presence, let them have overnight, because they've been having, plus the
No, my
photos,
lord.
if they're to be seen, they've had a wonderful
So,
time.
And during the summer vacation.
Let it be
from
posted
10 a.m.
immediately after vacation.
10 a.m. on 1/4/2026 till 5 p.m. on 4/5/2026. When counsel the petitioner submits that any of the allegations that are leveled against the father where a POCSO matter is pending, it is not in the interest of the child to have the overnight custody. It is submitted that in the earlier order, this court has, when the High Court has clarified that the grandmother should be present, it is submitted that so many times, in spite of the absence of grandmother, the father is exercising the visitation. It is submitted that it is not in the welfare of the minor, welfare of the girl who is aged about
5 years, my lord.
5 years. And counsel appearing for the respondent submits that in fact the father had exercised the overnight visitation several times, only with an intention to see that the father will not have the visitation at the fag end of the vacation. They have come before the court. Then counsel submits that the court may interact with the child and the things will be clear. And she submits that if the time is granted, she would be placing all the photographs and all on record to show how well the children are going, how the children are going well with the father. Next, having heard so and so. Admittedly, a POCSO case is registered against the father. What is whether it is only to implicate the father such a complaint is given, or there is any genuine, is it a genuine complaint? This court cannot ascertain or have an impression on that at this stage. Earlier, this court has passed an order permitting the father to exercise the visitation in the presence of the grandmother. This order is pertaining to Dasara, Deepavali, summer, Christmas, in the interest of both the parties. As today being the last working day, and Dasara vacations are approaching. In these circumstances, this court is of the view that in the interest of both the parties, this court is passing the following order.
Because in fact, it's 4 nights that the court has granted.
No, because the court has granted, we will extend it by another 2 days.
Lordship.
On
She also,
27.
she also needs to enjoy the holidays.
Wait, please wait. 27/9/2025, 27, 28, 29, 30, 1st, and 2nd. Until the second, on all these days, the father shall pick up the child at 10 a.m. and shall drop the children back by 6 p.m.
Yes, may I,
But maybe 5 PM, my lord.
yes, in fact, can I ask for 7 PM because even that would give him considerable time to enjoy with the kids.
Lordship,
Yes.
the mother will not get any time to spend with the child if it's going up to.
No, what will happen is 4 days, the entire 4 days, day and night is given to the father. Now the court is restricting it to 10 to 7. So you can't bargain on that anymore now.
20.
Let's just matter after vacation.
Yes, may I request for a date, my lords, and should I keep the,
You can move the court because
I can-
if every dates are given, then it's been difficult for the next court.
please, my
So,
lords.
so my lordship, just it's pick up at 10 AM and drop at 5 PM.
7.
Okay, 6, my lord, please. Because by the time they come home and.
Overnight is already
However,
taken away, so that
the
is the
grandmother
reason I.
ought to be there, my lord, in the presence of the grandmother.
Grandmother shall be there and the father is exercising the visitation. Yes.
Plus, now that overnight is not there, should there be a rider? I'm just asking.
No, ma'am.
Because let him get time with the kids. I don't
What will happen
understand.
if the grandmother is there?
Well, sometimes even she wants to go for the festival, then he will have to force her to and keep. That's exactly because it's not overnight. May I request the
gets
court
defeated.
not to put a rider, my lords, that's all. A condition should not be put that.
If not grandmother, some other
Yes,
Lordship,
there
let
is,
it be,
my lord.
my lord, let
There
it be
is.
grandmother, my lord,
But
please.
not
She's
at
not
all.
comfortable. with
other
anybody.
female member of the family.
Yes, any female member would.
Member of the family.
Grateful,
Yes.
my lords, great.
Till number 21, P. C. Shivanya Gowda for
Yes,
admission
Mr.
matters.
Shivanagowda.
Council has requested, he is not keeping well.
Yes, this is
Therefore, it may
matter
be-
after vacation 22.
22, till number 22.
This is a matter he was requesting yesterday. Yes.
Lordship
What
could
is
have
this?
passed an order like.
Ah.
The case of death, 70-year-old.
70 years, claimant is the wife. And the income, the accident is during 2018.
Sole claimant, my lord, 50% deducted by the MSCT. No, my lord, I did 1/3 only. I
Who
give
are
it-
there?
Wife alone, wife alone.
Wife is also there.
Only wife, only. Claim by only wife.
Oh, it is 50, now we are doing it 1/3. That's the only difference.
That is only.
And income,
Conventional heads also same?
I added 44 and 36 as my lordship is awarding in other cases.
The income has to be increased.
Income 12,500
Put
instead
have
of
taken how much?
8,000. I've written all those things. Anna.
Please come. Agreed with the award passed in MSC number 7148 of 2018, dated 27th August 2019, whereby the claimant is before disposing enhancement of the compensation. The claim petition is for compensation of an amount of rupees 40 lakhs. The tribunal had awarded the compensation as per the table given below at page 13. Land counsel for the petitioner submits that the court had taken the income at rupees 8,000 instead of 12,500. It is submitted that the court ought to have deducted 1/3, but the court had deducted 50%. 50%. And it is submitted that even under the conventional aid also, the amount that is awarded by the tribunal is not just and reasonable. Then counsel appearing for the respondent insurance company submits that the court had rightly granted the compensation, no interference is called for. Next, having heard the counsel on either side, there is a material on record. The accident had taken place in the
2018.
in the year 2018. Hence, as per the chart, this court is taking 12,500, and as rightly contended with the land counsel, the petitioner 1/3 has to be deducted. 12,500.
1/3 deduction into 12 into 5.
12,500. Future prospects?
No, my lord,
What is
70
it?
years.
70 years. 12,500. As he is 70 years, he is not entitled for any future prospects. If the 12,500, 1/3 has to be deducted towards his personal expenses. 12,500
5 lakh.
into 1 divided by 3. It comes to 4166. 4166 minus So from next time you have to do like this. Contribution to the family is 8,333 into 12 into 5. Loss of dependency would come to 5 lakhs. Towards consortium, 44,000, funeral expenses 36,000. Medical expenses, court has already granted 15 lakhs 43,038. The claimants are entitled for an amount of rupees 21 lakhs 23,038. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 18 lakh 53,038 to 21 lakh 23,038. Enhanced amount shall carry 6% interest. Yes, next.
Cell number 23, T.H. Venkatesh.
What about this?
For the fourth respondent.
I'm seeking for enhancement and compensation under 3 grounds, 3 heads, my lords. One is future prospects, my lords. Then one is under laid up period, my lords. And third is under future medical expenses, my lords.
Where is the table? Come to the table.
Page number 24, my lords.
So pain and suffering, no, you're not seeking any enhancement.
My lords.
75,000. Then medical expenses?
So as per the bill, my lord. As per bill, my lords, 198 is what I asked, my lords. 137 is granted, my lords.
What do you say?
My lord, by calculating, my lord, the bills, my lord.
Where do you get
My lord,
that?
the order says there is repetition. Therefore, they do not consider, my lords.
Then
I'm just placing it before, my lords.
no. So we will restrict it to that. 1,37,004. Then how many days he was in hospital?
Almost 3 months, my lords. In that
3 months, then he needs to have incidental expenses more.
Please, my
3
lords.
months is 90 days. Where do you get that? He's there for 3 months.
My lords, incidental, my lords. I'll just.
My lord, it is about 50 days, my lord. From 7/3/2019 to 18/3/2019.
On three instances, my lords, from 7/3/2019 to 18/3/2019.
Para 19, you lost.
Sorry, my lords, 19. And second, my lords, 9/3/19 to 11/4/19. And on third occasion, my lords, 15/7/19 to 27/19.
It comes to approximately 50 days.
It comes to 50 days. So we'll grant another 10,000. That is 50,000.
Please, my lords.
Then loss of income during later period. Which year is the accident?
19, my lords. My lords, notional income is 14,000, my lords. They've considered 11.3 is.
No. 14,500 is considered.
That is
Come
wrong.
to the chart.
No, that is wrongly printed.
It's 11,300 is what they've
When we
considered.
see, my lord, page
It has to
20.
be 14,500.
Please, my lords.
How many? How he was there? Then we will take 4 months.
Please, my lords.
14,500 into 4 comes to less than that only. It's coming.
The tribunal has taken 6 months.
Oh, 6 months. 87,000. Then loss of future amenities. Why there is
My lord, then you lordship, make it 5 months instead of 6 months.
6. Please, my lords.
because he's
My lords,
there for 50 months. 50.
25% is the disability, my lords. That is his lower limb and upper limb, my lords. But the whole body they've considered is at 8%, my lords. That has not been considered, my lords. They said
Let's see that
page number 32, my lords.
loss of future. Where is that? 30?
32, my lords. Page number 32 of the petition.
Loss of future earning capacity. Come
Yes,
to
my
page
lords.
20.
My lords, may I please read, my lords? The disability certificate exhibit C4, it is mentioned that that petitioner is unable to sit cross-legged and squat. Further, it is stated in X-ray revealed union of fracture. Considering the nature of work of the petitioner, who is a lab technician.
This is a weird reasoning given by the.
Please,
so let's say loss of future earning. What is the age? What is the disability? How much is the disability?
25% of the
To the limb.
limb, my lords. So
8% to the whole
correct,
body.
man. Please, my lords. Head body.
So loss of future
My lord, the observation of the, my lord, of the trial court is, my lord.
I've seen that. I've read that.
Doctor has said fracture is united. Fracture is united.
The disability
And
is a
this
disability.
disability will not, my lord, come in the way of.
3,500
his work.
into 12 into.
Then may make one submission, if your lordship is awarding under this head, my lord, loss of amenity is awarded more.
That we will see.
So that we
That we will go. That
we
we
have
will
to
see.
reduce it.
Yes. 14,500 into 12 into what is the multiplier?
18, my lords.
18 into
8%.
8 by 100.
It works up to 241,920, my lords.
12 into 18 into 8 divided by 100. 2,50,000, 560.
Please, my lords.
Then this future amenities of 1 lakh will not come.
Definitely.
So under the head of loss of amenities, for this we will grant 25,000.
Please, my lords.
Then conveyance attendant. What is this? Already incidental expenses 40,000 is granted. Again, conveyance and attendant charges another 40. Now we will lose that also because court is again making the calculation.
I leave it to my lords.
Loss of amenities. Then there is no future operation.
No future. Future medical expenses I've asked around 1 lakh, my lords.
No.
So there's no operation, my lords.
Where do you get that? Loss of future medical. The petitioner pleaded he requires so and so. Doctor has not said petition is need of future treatment or surgery.
But few frequent medical checkups he's been going through that. Therefore, I'm just some nominal amount may be granted, my lords.
There should be doctor's evidence in that regard.
Even pain and suffering is also on the higher side, my lord, 75,000.
No, everything we will not at your without there being your appeal. Already I am interfering with so many heads.
Please.
It's coming to 6,34,988 against 4,60,786. Please come. Agreed with the award passed in. When is the first one? Agreed with the award passed in MBC number 349 of 2019, dated 29th April 2023, whereby the tribunal has granted compensation of an amount of 4,60,786. The claimant is before this court seeking enhancement. The tribunal has awarded the compensation as per the table given below at para number 19 extract. Land counsel submits that when the court under the head of the court under the head of loss of income during the later period had granted the less amount without even considering unconsidered the income at 11,300. It is submitted that the accident had taken place in the year 2020 and there. What we are taking, you said 14,500.
14,000 is what I told you.
Oh. No, the entire thing has to be changed. I calculated
241,920 minutes. I've made the calculation.
14,000 into 4 into 6.
Into 12 into 18%.
1 minute. 14,000 into
6. Correct, man.
84,000.
84 minus 86.
Then 14,000 into 12 into 18 into 8 divided by 100 is 2,41,920.
Please, man.
I've taken 4,500.
14,500.
It comes to 6,23,348.
Even under the head of later period, there also we have to reduce 500.
That also I have reduced.
Laid up
40,000.
I've taken in the year 2019, the court ought to have taken 14,000. This submissions. 14,000. It is submitted that the future when the disability is 8% to the whole body, the court had granted 1,000 without implying the multiplier. It is submitted that the amount that is awarded by the tribunal is not just and reasonable. Next, land counsel appearing for the respondent insurance company submits that the court has granted a just and reasonable compensation. No enhancement is called for. The having heard so and so, the tribunal had under the head of pain and suffering, court had, and medical expenses, court had granted reasonable compensation, and this court finds no reasons to interfere. For the incidental expenses, court under when he was in the hospital for 50 days, court had granted 80,000, and the same is made to 50,000, reduced to 50,000. The loss of income during the later period, 14,000 into 6, 84,000. Coming to the loss of future earning, When there is a disability of 8%, court ought to have considered the same. Hence, 14,000 into 12 into 18 into 8 by 100 is 2,41,920. Under the head of loss of immunities, considering the disability of 8%, this court is granting 25,000. In the light of the law laid down in Mekala also so-and-so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 6,23,348. Accordingly, the appeal is partly allowed, enhancing the compensation from 4,60,780 to 6,23,348. Enhanced amount shall carry 6% interest. Yes.
Cell number
Obliged, my
24,
lords.
Satish Chandra, KV.
Yes.
24.
The petitioner, Your Honor. In this case, she got already divorced and she is in a doctorate, and already we are admitted 3 lakh rupees for the permanent alimony.
After vacation, after vacation.
Because in the counseling is there in the chamber also.
We will see after
Yes.
vacation.
Cell number
25.
25. P. Mahadev Swami.
After vacation? After vacation. Yes.
Cell number 26, Disport 27. Kashinath JD.
Can it wait till vacation?
Calculation, that interim order of this honorable court is complied, my lord. I have filed, my lord, in spite.
It is submitted that the interim order of this court is complied with.
Till today, what exactly
Partially, they complied, my lordship.
Yes, my lord,
After
we
the
have
issuing of the warrant, they
Counsel
complied,
for
my
the
lordship.
respondent submits that the order is partially complied. Mrs. Mata.
No,
I obtained that ordership, my lordship. They are continuously, they are absent before this trial court, my lordship.
Matter after vacation, next 28.
Cell number
The
28.
interim order will be vacated, continued, my lord.
It is.
I am apologizing.
No, we will vacate.
No, my lord. Interim
Don't
order-
take back the words.
No, no, no.
My lordship, there, because of this interim order, they
Kindly
are not appearing in
Matter
there, they are
after
not making the
vacation.
payment, my
We
lordship.
will see counsel after vacation. 28.
28.
Kindly, my lord,
Zamir
one
Pasha.
submission, interim order, otherwise my FLW is operating,
I said it is extended.
obliged.
Yes.
Cell number 28, Zamir
I
Pasha.
appear for the petitioner. This needs to be heard. It's on the
After
issue of
vacation.
maintenance, yes. Can we take
Vacation
a
will
date which we can suit both of us, 29th
Yes,
October?
29,
Great.
yes. Next
Number
20.
29.
Yes.
This case appearing for respondent, Your Lordship.
Oh.
Yesterday, Your Lordship directed them to hand over the children,
Oh.
but they have not given hand over the children to us, Your Lordship.
Oh.
Again, they came.
There is a counsel. This court yesterday has directed the father to hand over the children to the mother. The order of the court is not complied with.
Appealing for petitioner, my lord. My lord, the petitioner and the children are present, my lord. We tried to persuade the children to go with the mother. The children refused, my lord.
What is the reason?
My lord, there are several reasons, my lord. The main reasons which the children are citing is that, my lord, on the last occasion during the summer vacation when the children were with the mother in compliance of the order, my lord, the mother and the brother of the mother had slapped the elder son. And also the mother was leaving the children at home and she was going out and she was not taking care of them. And also on in August, on 3 occasions when the children came here,
So when
she
his father
did
will
not,
never go out. He will always sit at home.
he's doing work from home, my lord. He's a software engineer.
He's software engineer.
He's doing work
Always
from home.
sit at home. He'll not go anywhere.
If he's going out, he'll take children with him, my lord.
Very, very unreasonable grounds and making the children at that age saying that we don't want to go to
My lord,
the
I have
mother.
instructed the petitioner several times. Yesterday also, even I tried to persuade the children, my lord. You can ask respondent counsel and also the respondent mother, my lord. If they say that I didn't do that exercise, my lord, then I'll accept whatever order you lordship is
They
passed,
should
my
be,
lord.
compulsorily they should be, sent to her. No consent from them.
I understand, my lord, but the children are not agreeing, my lord. In spite of,
Not agree because they're nicely tutored.
my lord, even I tried to forcefully take them to the mother, my lord. They snatched their hand away and they ran off, my lord. And that was the apprehension, my lord. That is why they didn't go. The apprehension was that if we send with them and if they run off from there, my lord, if something happens to them, that was the apprehension. That's why they didn't go, my lord.
After vacation and we'll treat them properly, treat the father properly.
It may be referred to mediation, my lord. If
No mediation is
some,
required. What mediation will be done?
my lord, so that mother can meet the child there and if some bonding happens between the mother and children, then the children may agree to go with her, my lord. If we try to simply forcefully,
From how long they are staying with the father?
my lord, from almost
2.5
2.5 years, my lord.
2.5 years, they never went to the mother.
My lord, in complaints of the interim order, my lord, they have gone 2-3 times, my lord. And also in summer vacation, also in complaints of the trial court order, we had sent, my lord.
So small, he can't even understand. He says he refuses to go to mother.
My lord, I'm speaking of elder son, my lord.
Younger one?
Younger one is also refusing, my lord. He says, if his brother is not, then I'll also not.
Your lordship, last time,
In fact, I tried everything, my lord. You can ask respondent counsel and also the mother, my lord. In fact, yesterday 2 times I only took the children and left with the mother, my lord.
Ask him why he doesn't want to go to mother.
ಯಾಕಪ್ಪ ಹೋಗಲ್ಲ ನಿಮ್ಮ ಅಮ್ಮ ಹತ್ರ ಅದೇ ಯಾಕೆ ಹೋಗಲ್ಲ ಕಾರಣ ಹೇಳು.
ಮನೆ ಬಿಟ್ಟು ಹೋಗಲ್ಲ.
What he says?
He says he will not go leaving his father and his house.
Huh?
He's saying he will not go leaving his father and his house.
What did the mother do to him? Ask him.
ಅಮ್ಮ ಏನ್ ಮಾಡಿದ್ರಪ್ಪ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೋಗಿದಾಗ?
Not last time. Don't put words into
Okay,
his
okay.
mouth.
ಆಯ್ತು, ನಿಮ್ಮ ಅಮ್ಮಯಿಂದ ನಿಂಗೆ ಏನಾದ್ರು ತೊಂದರೆ ಆಗಿದೆಯೇನಪ್ಪ?
He hit me.
So what? So what? What happens if she hits you?
My pain.
If your father hits you, you won't stay with your father.
My father did not hit.
I'll ask him to hit. So that you'll get used to it. How can you say that you will not go to your mother just because she hit you once? Doesn't she love you? Who told you? Your father told you?
No.
Then how do you know?
She'll not. I'll not go with her.
Why?
Because she left us.
Your lordship.
He has now come to the correct point. Left you or your father?
Both, my lord.
Left us.
So that you will not forgive her.
No.
Force us to go to them.
What he says?
Don't force us to go to them.
We'll see after vacation. Enjoy vacation. After that, we'll send you to your mother.
No, I'll not go.
We'll see. Yes, Liz is smarter after vacation.
Yes.
Your lordship,
But
the Sarah vacation was given, your lordship. Last time, your lordship.
Under these circumstances, what is the submission, Mr. Counsel? We'll see. At least we should understand what is happening. How can you compel them and will you drag them to the house or what? This is matter after vacation. Next.
Number 30, H.M. Gopal. Pratima SK.
2 writ petition.
First,
See it after vacation.
please, ma'am. Interim order may kindly be.
Interim order.
Last time he was directed
Number.
to pay the interim.
You ask your client, she is present. I confirm the
I
entire.
have the memo.
No, no,
She has received only 20,000.
Alla,
She is
morning-
here.
No, no, no.
She is here.
If the interim
I am
order is
also-
not.
That's exactly the direction, my lord. Your lordship it also.
The learned counsel for the, 1 minute, learned counsel for the petitioner submits that the entire amount is paid.
We agreed. Morning I
And the
confirmed
learned
it to you.
counsel appearing for
Memo
the
for
respondent
calculation and
submits that
producing.
the amount is not paid. This court has passed an interim order. If the interim order is not complied, already there is a clause that if it is not complied, the stay stands vacated. In these circumstances, the court is not inclined to clarify any of the aspects. If the amount is not paid, it is for the respondent to execute the order. Yes,
number
next.
31.
May I? This is matter after vacation.
May be permitted to file the memo, madam.
The memo before the
I
registry, not
confirmed it to the client.
before the registry, not here.
She said entire amount has been received.
Yes, 31.
Morning she
31,
said.
31, Vij Bhattaya, MC for petitioner.
For
Pavan Kumar
respondent, my
S.
lord.
Yes.
My lord, court has ordered for 20,000 of maintenance to the wife, my lord. Husband is getting 1,12,000 salary, my
It has to be heard finally.
No, my lord, I am paying you very.
After
much.
vacation, next, 32.
Please to extend the interim order, my lord.
Interim order only granted is extended. Next, 32.
Number 32, Anjumani.
Petitioner in this case, my lord. My lord, the husband and the children were directed to appear before this court.
The father.
The custody matter, my lord. My application was rejected. I am for the mother, my lord.
For visiting the child.
No, my lords, it's for custody. My lords, every time they make the submission, say it was for visitation, it was visitation. The application first was for interim custody. I am the I filed the petition for seeking custody of the children. The children are with me. In the interim, they filed an application for seeking interim custody. While that application was rejected, visitation rights was given to her. Now, subsequently, what has happened?
Visitation now.
Visitation is every day between 6 and 7 p.m. Outside the house. And
No, my lord, no. Interim order may be.
This is the conduct of the parties every time. They don't even let us submit. And wrong submission. Even on that yesterday, they said he is absconded. She's kicked him out of the house.
No.
After.
My lord, this is the message. Last.
My lords,
Yes.
my lords, I'm privy of the how this court has to be conducted in this particular matter. And my lords also wants one person to go submit or one counsel to submit. If I may be permitted to submit, my lords, because I'm the aggrieved party in this instance. What has happened is, my lords, she was never inside the house. On 7th of May 2024, she's left.
At this hour, we are not going into all that.
Please.
What is the interim order that is passed by the family court?
That is visitation rights, ma'am.
Is it happening or not happening?
She is not enforcing the visitation rights. Now, my lord, still till August, 20th of August, what has happened is she was never inside the house. And she has protested outside the house. She has to the news channel, Zee Kannada, Sakshi newspaper, saying writ petition. In writ petition, she's agreed she's taken her house on rent. Subsequent to filing of this writ petition, she's gone and filed a domestic violence petition saying, stop me from being dispossessed. She's entered the house using that order, breaking down the doors. And when a divorce petition is pending, and my lords, when a custody petition is pending, she's entered the house. Please, my lords.
Interim order may be granted.
There cannot be any interim order in this particular matter, my lords.
33.
Till number 33. I don't go in right.
After vacation.
After vacation.
Just one small point, may I make a submission, my lords? This petition is filed against a rejection of an ex parte order by the family court. Parties have got a mutual consent divorce decree in 21, where the custody of the child is given to the father. 25, the ex-wife files a suit saying that marriage is.
But I asked him when the matter came up.
Exactly. And
no, you want to say that.
And against the ex parte order, family court has said this is a matter where other party has to be heard. Can any court set aside a decree without hearing another? What is the writ?
You have to pass an order after vacation.
16th, can it be taken on 16th?
Dates I can't give now. Yes, next.
34. Josna.
Because the contempt is on 15th, only for that purpose. We have filed 16th if possible.
On 13th. Yes.
No, 13th, I'm not in station, my lord. I'm sorry, I'm appear for the petition. I'm not in station on 13th. Any other day?
14.
14.
Yes, next.
My lords, serial number 34, my lords. When the matter came up on 23rd, they were asked to seek instructions whether the mother would like to have the first half or the second half during the
That's a tiny thing that needs to be brought to the attention of the court is the son is in 10th standard right now. There is no such thing as vacations for him. Only 4 days has been given. 4 days has been given, wherein 1st and 2nd is a holiday, 3rd to 4th there is school, and 5th to 7th there's a holiday. And from 1st to 7th, his tuitions do not end. Tuitions are still there. So there is no something called a vacation for a 10th standard old person.
I'm getting late. It's already
My lords,
yes, my lords.
my lords, kindly, at
There
least,
is a precedent
I will
that is
handle
already
the tuitions.
My lord.
Whatever it is, I will take them to the tuitions. They
There is
can't say
already
that
a
it is not
precedent
there.
set for the previous vacation that
can't
has
avoid
happened
it.
after they have separated themselves.
I've not seen the children since February.
The precedence is that they have been in the vacations. They have taken the children. He has taken the children to malls, games, and etc. etc. The same can continue this time as well when there is holiday for the son. There's 2 sets of holidays: 1st to 2nd and 5th to 7th.
I'll pass orders. Next 36.
Serial number 36. 35.
Serial number
35. Srinivasan.
Serial number 35. Respondent, my lord.
It's already morning. It is adjourned.
No.
Adjourned? No. 35.
Yes, my lord. I am for the respondent, my lord.
Yes, 35 also after vacation. Interim order is
My
there
lords,
extend.
my lords, if
36.
it may be listed immediately after vacation, my lords. The
He come
respondent is
immediately after
precipitating-
vacation. Yes, yes.
Liberty may be reserved to move the vacation. If liberty may be reserved
Why?
to move the
What
vacation
is
bench,
that?
my lords. The respondent is precipitating the matter, my lords. The respondent has been granted visitation rights, my lords, but the child is not willing to go to the father, my lords. And they are precipitating the matter in the
It
miscellaneous
is.
petition, my lords.
Which case it is?
Seal number 35, my lords.
35 after vacation.
Seal number 35, my lords.
35.
The petition is permitted to move the vacation court. Yes, 36.
Serial number 36.
After vacation. All other matters
My
after
lords,
vacation.
34 interim order may be extended.
Interim order,
34.
wherever interim order is there, extend. Passed over for what?
Serial number 8.
Please, my lord. Lord, apologies, my lord. Some clerical mishap has happened. Process to be paid will make it good tomorrow itself.
What is that?
Process is not.
For 8.
You have thought
Not no, last occasion some order has been passed. The PCR is
10 days ago.
Yes. That's happened.
after vacation, sir. After vacation.
Court officer, madam.